Good morning, folks. This is Rob Litz with U.S. Arbitration and Mediation in St. Louis. I'm thrilled that you're joining us for our best practice program today. This is our 89th CLE that we've been presenting now for close to 20 years. We have a fabulous program. A couple of just housekeeping measures, if I could. First, if everyone could mute their audio throughout the program. We'll ask our first speaker is Ellen Harmon and crew to both unmute and click on their video so they can be with us in just a second. We are going to have three outstanding programs. And the first one on strategies involving medical malpractice cases. It's something that we see quite often, and it's an area of interest that's evolving, and we have five outstanding speakers. Ellen Harmon, who is going to introduce the others, and all of the bios, by the way, are at the end of the materials that you will see that were forwarded to you. So I'm not going to read through all of Ellen's, which are substantial, but leave it to say that as a lawyer, as a registered nurse, someone who has an MBA and years of experience involving her work as in-house counsel for the largest ambulance and air ambulance company in the world. She's seen a lot of things over the years and really uniquely qualified to mediate these cases. Couple of things. We're going to go for 50 minutes. My sense is that we're going to have enough material to put us in a position to have you ask questions at the end if we have time. All of the presenters have been gracious to agree to answer any of your questions. And the last slide on Ellen's slide deck has her email address, and you can forward email questions to her. We're going to go ahead and get started. Let me share the screen so that we can pull up their PowerPoint. And Ellen, if you would unmute and click on your video, there you go. We should be all set. Ellen, take it away.
Okay. So good morning, everybody. Welcome to USA&M, and we're going to talk today about resolving medical malpractice cases through mediation. We have a great panel who's put a lot of work into this. They helped me to prepare these slides, and I really appreciate all of their input. I'm going to start with Erica. Erica is on my left here, and Erica is with the Simon Law Firm. She practices plaintiffs, primarily plaintiffs' cases, and she specializes in complex medical malpractice, wrongful death, and personal injury. She's been recognized by Best Lawyers in America, Missouri and Kansas Super Lawyers, and Missouri Lawyers Weekly. And she is involved in a lot of litigation and has had some very successful results. And you can find more about her and everybody else in their bios. And to my immediate left here is Graham Dobbs. And Graham Dobbs, like myself, is a nurse attorney. And Graham also practices on the plaintiff side. And he is with Graham Ritter Gray Ritter Graham, I'm sorry. Excuse me, Gray Ritter Graham. And in 2023, he was recognized as St. Louis Lawyer of the Year in the category of medical malpractice. And to my right is Phil Willman. And Phil Willman is defense law, and he's been a Brown and James for quite some time now. He specializes in representing healthcare providers in medical negligence and in medical device manufacturing. He's the past president of DRI and still very actively involved in DRI and serves on the executive committee for the National Foundation for Judicial Excellence. And Steve Fields is a partner at Brinker Doyen, and he practices insurance defense, specializing in personal injury, professional liability, medical malpractice. And Steve has a very active family life, and he likes to spend a lot of time with his family when he is not practicing defense law. Okay, and so next slide. We're just going to have a brief overview. So today we're going to talk about getting ready for your case and preparing your case not only for trial, but also preparing your case for mediation by arming your mediator and providing them with a background so that you can actually get something done at mediation, managing client expectations, pre-litigation settlements, the impact of the National Practitioner Database, managing multiple defendants. As all of you who are involved in medical malpractice know, many cases involve multiple defendants, and that can be very, very challenging to litigate and to settle in mediation. Punitive damage and their impact on negotiations and non-monetary remedies. This is a pretty volume-packed agenda, and hopefully we'll be able to get to all of this in the 50 minutes we have allotted to us. And Graham, you want to start talking to us about getting prepared for your case?
Well, thank you, Ellen. Yes, certainly. I was talking with a colleague at an event last night, someone who I've traveled the country with and worked on a lot of cases and resolved a lot of cases.
Next slide.
And the colleague said, well, I'm going to tune in tomorrow, so hello, and get all the secret sauce. And, you know, there's really not a secret sauce. There's no substitute for the basics, the fundamentals of what we all do as attorneys. And it starts with the preparation. It really does. And this applies to any kind of case you're going to try to mediate. You know, prepare the client, prepare your case, and then prepare and arm the mediator, prepare and arm the judge as you go to trial. And you want to prepare and arm the jury. So in the mediation preparation, for me, starts when I first meet the client and I first talk about what it is to try to pursue a medical negligence case or a case against any kind of healthcare provider. So you want to make sure that client understands the pool they're jumping into and some of the challenges that they're going to face, that we're going to be faced with, what our burdens are to prove. And so that starts sort of day one when I'm talking with the client, and will continue up through mediation. This is, and I think it's true for all of our clients, except for the corporate, you know, healthcare clients, certainly individual medical providers with a few exceptions. This may be their first and only case they've ever been involved in. And certainly that is, I can't think of a single client that I've had that has had more than one major litigation issue. And here it is, we're in the middle of it. So this is their first and only introduction into what mediation is, and to try to prepare them the day before the mediation or when you're sitting in the room with, you know, waiting on the mediator to come back is not a recipe for success. So I like to make sure we've addressed all of these issues. So what is our burden of proof? What are the things we're going to have to prevail on, both in causation and standard of care? Here are our strengths. Here are the weaknesses I see. Here are the benefits to mediating a case, to trying to resolve this before you put it in the hands of 12 strangers on a jury, versus what are the risks of you know, doing that, going to trial. I looked last night again at the national numbers, and well over, I think currently well over 80% of medical malpractice cases will resolve one way or another prior to trial. And the numbers that of the cases that go to trial, they're still, again, well over 80% are won by the medical provider. And there's been some research that breaks that down into how strong people think those cases are. And even the strong cases sometimes can be, of that small percentage that go to trial, can be sort of a coin toss. So if the client has a realistic expectation of what you can accomplish for them, given the challenges you're going to face, you're going to have both, you're gonna have non-economic damages caps. Where does their case fall? Is it a non-catastrophic cap, or fits within the catastrophic cap? So I want my client to understand that and to know these things long before we get to the point where we're gonna make a demand and then go into mediation, and understand why we're making the demand we're making and the position we're taking mediation. My partner, Marcy Graham, always says that the client doesn't care how much you know until the client knows how much you care. And that's really true. So there's no substitute for spending that time with the client and understanding, helping them understand what you can accomplish for them and what their risks are in taking the case to trial, and what the benefits are in settling the case. And what to expect and how to react during mediation. It's a lot of hurry up and wait. And it's going to be my client and myself sitting in a room waiting for the mediator to come back in, and what we're going to do in response, and how the client is to react when the mediator comes in. So a lot of times a client this will be their only opportunity or their first opportunity outside of the deposition to really tell the story. And sometimes it's cathartic for them. And no matter, what you do to try to prepare some folks, they just have to get that out. And so sometimes that has to occur. And a good mediator will, be able to sort of filter that and listen to the client. So that's a benefit to the client, feeling that they're being heard, and at least having a day, to present this. So, stepping.
Next slide.
This is really preparing the case, which is what you're gonna do, regardless. And all of us do this, all of us make our points with the opposing witnesses, the opposing experts. And where you can find that expert's publication that says exactly what you say in the case, the record that says exactly what you say, the policy that says exactly what you say, and get them to agree to it or look ridiculous not agreeing. Those are all the preparation things we do as good trial attorneys. And so you have hopefully prepared your best evidence as you work the case up. And then your job is to arm the mediator with that. And sometimes, Ellen, we've not mediated a case yet, but if we do, you may get sort of a mini trial notebook from me. The key medical records, the key exhibits in the case, anything, the pictures, a picture paints 1,000 words. So if you have that X-ray or the radiology film slide that shows the giant defect that's apparent to even lay members and members of the jury, that everybody on the other side says, well, now in retrospect, I kind of see that, include those things that help arm the mediator with the strengths of your case. You're going to be challenged by the other side, no matter what it is. So address what you anticipate to be those challenges you're going to face, and address that in your position paper with the mediator, and think about how you're going to respond to that when they come back in the room.
Next slide.
So one thing that's really key, and I think we would all agree, having spent a lot of time doing medical negligence work, is that there's no substitute for experience in that field and in that milieu. Former judges, litigators with experience on both sides, even one side or another, that know the challenges each side faces and know what the risks are, know what the value is. So, choosing the mediator, someone that my opponents would find credible. We typically don't have a lot of trouble agreeing on a mediator that's acceptable to either side. And so as long as that mediator has a good track record, I know that mediator is going to work hard to try to push both sides toward a resolution and knows what they're talking about and has credibility with the other side and is going to make a good impression and put my client at ease and let my client feel like they're having, you know, a day that they're being heard and treated respectfully. That's a good mediator, and that's someone I will agree to use. So as I've said, you want to prepare that mediator, you want to get them your position, your best evidence, arm them to go in with your demand and explain why that demand is reasonable and why it should be paid. You're going to want to have thought about any rights of recovery or liens well prior to the mediation. Number of things, you know, whether it's hospital, ERISA, Medicare, Medicaid, even work comp, they all have their own nuances. You'll want to do your best to know what number you might be facing in terms of repayment, and then what your odds are of getting a reduction on that, whether through Medicare pro rata, sort of the regulatory and statutory reduction scheme. Same thing with Medicaid. Often Erica's job, my job is not over when we reach, you know, a final number at mediation if we have a significant lien to resolve. And so we will face that for likely months following the mediation to finally resolve that lien. And so that you need to go in armed with that number. I guess the final thing I would say, and I prepare my client for this, is that no matter how we like to think we use an enlightened approach and we all come in and we can get to a similar number or it's amazing to me how many times we would all come from the different angles we come from and end up within a pretty close or a similar range. You think we could get to it quicker by now, but this is the process. So you want a mediator that will stick to it, that will, if you don't quite get there that day, it's going to follow up and try to push that a little further. But that day, as long as people are still talking and moving, it's worthwhile to at least listen. So I prepare my client to stick to it, and I tell them, you know, nothing good usually happens till after 2:30 in the afternoon. So, and it, you know, your good mediator will follow up on anything you've left on unresolved that day.
It's always important to follow up and to, if you don't resolve that day, to reach out to the mediator or for the mediator to reach out to the parties and try later on. Sometimes people renegotiate and cases settle a week, 2 weeks, even the day of the trial. Next slide. Erica, could you talk to us a little bit about timing of mediation?
Sure. So hello, everyone. Again, I'm Erica Slater from the Simon Law Firm, and thanks again for joining us today. My colleagues and I at the Simon Law Firm spend a lot of brain power on talking about how to make mediation more effective in our cases. I'd say we've probably walked away from more than 50% of mediations not being successful. So that brain power, when we're thinking about mediation, usually goes towards new strategies or developing new ways to make mediation effective in our cases. So my goal today in the couple of minutes I have to talk to you is really to share kind of a toolbox that we've used you know, over the past several years or so in different cases when it's appropriate. All of these tools are not going to be appropriate for different cases. So I encourage you to think about your particular case and the timing of the case and whether one of these strategies can potentially work for your particular case. And I'll share some things that have been helpful for us in working with the defense as well that make the job easier for both sides. So as far as the timing of mediation, I think that's probably one of the most important things that you can do in a medical malpractice case. If you have outstanding motions pending in front of the court, or there is some big uncertainty in the case, maybe a key witness that needs to be deposed, or anything that could change the tide of the case for both sides as far as valuing the case. That is not the right time to mediate. You need to get on the other side of that, especially if it will change the course of the case. You think from the plaintiff's side that may be, you know, if you're uncertain if you are going to win that motion or if that deposition is going to go well for you, that might be the best time to mediate in case it doesn't go well for you. I would argue to have some patience and to get past that point in the case, because you are vulnerable if you don't know where that is going in your case. And if you lose that motion or that deposition doesn't go well for you, then you need to understand the value of that case, because it's never going to get any better. And that's just what that particular case is. You need to wrap it up and move on. The timing of mediating is also important, so all parties are properly motivated. The closer you get to trial, obviously, the more motivated parties are going to be. And I encourage anyone looking towards mediation to have some patience in their case and not be too eager to do that, so parties are properly motivated. Rob, if you could change the slide, please.
Next slide.
So as far as, I call this preconditioning, or I'll also talk about potential preconditions to mediation. When I've been approached, I usually allow defendants to ask for mediation. It's appropriate since they are the ones paying in a case for them to ask for mediation. That's an appropriate thing to wait for in a case. If a defendant has asked me or another attorney at our firm to mediate, I believe it's an important thing to make sure you're kind of on the same page. If I think a case is worth millions of dollars and they think it's a six-figure case, mediation isn't going to be successful. So I usually have kind of a conditioning conversation. Nobody wants to talk about, oh yeah, we both agree that's a $5 million case or whatever it is, because then we wouldn't need a mediation. But having a conversation with the defense attorney and making sure you can speak clearly that you're kind of in the same universe, that will ensure that you're not going to waste time at mediation, and that might be fruitful. Also consider maybe some preconditions to mediation if you're on the plaintiff's side. Rob, if you can change the slide, please. One way we've used this recently, in a couple cases actually, is that we have suggested a number that the defendants come to the table with to be able to engage in mediation. I think this works in high value cases. It ensures that all parties are properly motivated and that we know that the defendants are coming to seriously settle the case. The reason we've done this is often when we're leading up right to trial, in that week or 2 weeks before trial, when our firm and our team is 100% in pretrial mode, taking a day out to mediate a case can be very crucial timing when you want to be preparing your case. And if that mediation is not successful, then you have lost a day of trial prep that you may really regret. So this is a strategy to say, hey, you know, we can mediate, but you need to start with X amount of dollars on the table before we mediate. We've all been in the situation where that first offer that comes from the other room is very frustrating. We all expect it, or on the flip side, the demand is astronomical. And getting past that initial roadblock this is a way to do that.
In high mediation cases, Erica, sometimes the mediator can suggest that defense will come in with a reasonable number. If they acknowledge that there is liability on the part of the defendant, if they come in, you know, north of 100,000 with their initial offer, sometimes that will help to get things going, as opposed to a lot of insurers want to start really, really low, which it can be very frustrating to the plaintiff's side. And starting off with a more reasonable number can often get things going.
Right, and that's worked for us in the past as well. Other examples of preconditions we've
Next slide.
other examples of preconditions that we've had success with is asking the defendants to agree to certain conditions that would apply to the mediation, such as, you know, we want to see all terms at the mediation or before the mediation that you would want us to agree to.
Next slide.
We can stay on this one.
Oh, okay. Sorry.
Thanks. Sorry, Rob.
Sorry.
And things like, you know, we would want you to agree to a certain amount of time that the checks would be exchanged after the mediation concludes. If there's more than one defendant involved, we may want a mediation with one defendant to be kept confidential from a different defendant. So there's a host of things to require on the plaintiff side of before mediation to be able to get to that mediation to make sure everyone is on the same page. The last thing I want to say that pertains to this slide is often defendants will ask for a demand prior to mediation. I never fight that. I think it's one of the most important things to do before a mediation, and it's appropriate to do it as early as possible. And that is not a defense attorney, you know, putting unreasonable demands on you. That's a help you situation. My understanding, and my colleagues can confirm this, is that allows them to get all the stakeholders they need to on the other side involved. It allows all parties to know how they're coming into the mediation and there are no surprises. So just like I mentioned that you can ask that a certain amount be put on the table, it's appropriate to change maybe those first numbers prior to getting into a mediation.
Thank you. Next slide. I wanted to talk just a little bit about the mediation part of things. In medical malpractice, the cases are very complicated and personal, and keeping the confidentiality of the patient can be a real key in trying to resolve this. Once a case goes all the way to trial, a lot of personal facts get presented to the public at large. And one thing that can really help to move mediation along is to emphasize the importance of maintaining confidentiality and meeting with both sides to establish trust beforehand, letting them know that you're going to listen and allow the parties to be heard. And also to caucus with the family and the defense before there's the meet and greet. Not instead of the meet and greet. I'm a big fan of having parties meet face to face when possible. I know sometimes there's so much animosity, it's difficult, but if there can be a face to face so that both sides can get a look at the other side, it really is helpful so that they can meet and greet and see that there's another person. Steve, could you talk to us a little bit about pre-suit mediation? Next slide.
Sure. So we do have those occasions where prior to litigation, we get notified of a claim and we can get involved. Do we want to try and mediate now? It's obviously more on the rare side when that happens. I think it's on those cases where really the facts of the case are pretty well known, and the parties are motivated to resolve this quickly. You know, why would we want to pre-suit mediation? Obviously, it saves on the expenses of litigation. I mean, both parties can look and say, okay, we can resolve this without having to file a lawsuit, retaining experts, and going through the process. We can certainly do that. One of the things that I know that I've had in the past is that it keeps a sensitive case confidential from the perspective of, is this something that if the lawsuit is filed and it gets out in the public, and I know that's, you know, but it brings it to light, or is this something that you even want to deal with? No, you want to try and settle it now. And I think the other pro that I think is something that Graham mentioned was it can be cathartic. It can provide both sides closure. I've heard, you know, from, you know, many a plaintiff's attorney, the family just wants to be heard at the mediation. They want, you know, they want their story to be told. And that if they can, you know, get this resolved and it helps them move on. And it's likewise for a defendant, you know, a physician or a healthcare provider. You know, I've had physicians tell me, you know, look, I don't, you know, this was an unfortunate event. I really don't want to deal with this anymore. You explain to them that, oh, by the way, you're gonna have to sit for a deposition. You're gonna have to sit through a week of trial or more, and that you're not gonna be seeing patients. You know, most of those physicians will tell you, I don't want to do that. I've had physicians that we have consent policies and they'll say, I didn't do anything wrong, I'm not consenting. And then you explain to them the process, you bring them to mediation, and then they understand, oh, this is gonna, you know, I don't have to worry about this anymore. Obviously, some of the cons, you know, if you do have unknown facts and that you just simply, there's too much that's unknown, and it's gonna make it difficult to resolve. There's gonna be disparities in what it is. You can only exchange so much information pre-suit. You can't take any depositions. I think on one case I had where I met the family and they allowed me to meet with the family. And of course, you know, the opposing counsel wanted to meet with my employees and my client said no, which made it difficult and we didn't get to an early resolution. And then there's where parties just don't want to resolve the case early. You know, I've got cases where it's to the contrary, the family doesn't want closure. They want to be heard in court. And I've got several cases right now where we can't even get them to the mediation table. Or likewise, you have healthcare providers that will say, well, I call this they want to show a sign of weakness. You know, they want to say, well, let's see if they file a lawsuit. Let's see if they do that. And it makes it extremely difficult. And there's terms that have to be agreed upon that make it much, much more difficult to get to a pre-suit mediation. It does happen, but I think it's more, you know, rare than it's the norm.
I found that in my experience as in-house counsel, the pre-suit mediation works best when there's known liability or accepted liability on the part of the defendant. And they acknowledge that, and it really allows for the family, the patient or their family to bring that closure early and swiftly when that's acknowledged, and you can settle before there's even litigation has ensued. So that's you know, that's a great way to try and resolve things early on.
Yeah, it's on the cases where, and I don't know, healthcare providers, but they'll apologize. It's the I'm sorry that you see. I know a lot more on the East Coast, but in those cases, you can get the parties to the table and try to resolve it.
Could you talk to us a little bit about your thoughts on punitive damages in medical malpractice? Next slide.
Certainly. So this is where you get the CLE credit for the presentation, so we can talk about a couple of cases. You know, punitive damages in medical malpractice cases are certainly rare. Do they happen? Yes, they do. Obviously, pre-2020, there was a statute, it was conscious disregard. In 2020, the legislature enacted a new statute that made it, I think, harder to submit on punitive damages. It's now intentional harm or malicious conduct, which makes it certainly more difficult. But we have seen cases on the medical malpractice side. I mean, my colleagues over here, their law firms have gotten punitive damages in aggravating circumstances, medical malpractice cases. The Rodin case here, this is a Missouri Supreme Court case, and they upheld the punitive damage award. You know, there were things that this doctor, I think in this case, that really was egregious in the Supreme Court's mind. I mean, this patient was reporting mild issues, and the doctor, instead of just trying conservative treatment, immediately went to the surgical option. He then took out too much during the surgery, and when the patient was having complications and started to decline, unfortunately, he didn't do enough and refused to perform any diagnostic testing. Those were factors that the court said clearly established that this was punitive damages, and they upheld the award. They were conscious acts I think one of the things that the Supreme Court looked at is whether or not the healthcare provider tries to intervene and treat the patient, because that, you'll see that in the next case, and in this case, it was very clear this healthcare provider did not try to treat the patient when faced with obvious complications in the surgery. And that's certainly a case where it can happen. Next slide, please. Now, of course, we have a recent case which came out this summer. This is the Frost case, and this was a opioid addiction case. The trial court certainly allowed punitive damages to go to the jury. The Court of Appeals, though, found that it did not warrant punitive damages. They thought the red flags were not enough risk factors, or were not enough to rise to the level of punitive damage. Were they risk factors? Sure. But the appellate court said, you know, we don't think that this was certainly rose to that level. We think the doctor intervened. The court thought that none of that rose to that level of complete indifference or conscious disregard. And in the opinion, they said it's an extremely high bar for the submission of punitive damages on a medical malpractice case. Next slide, please. So why do we have to deal with punitive damages, and how would they impact mediation? I think the threat of punitive damages can be used as a weapon to entice a party to settle. If you've got a case that has some really bad facts and is the potential for punitive damages, that's certainly a case that is one that would motivate certainly the defense on that case to settle a case. And they know that the possibility is there. Trial courts are certainly inconsistent on when they allow it to be submitted to the jury for punitive damages. I think there's times where they will, and there's times where they won't. And when they do, you're going to a jury of 12, and you don't know what they're going to do. You don't know what it could be. And then if they do give a punitive damage verdict, you're going to rely on the Court of Appeals in the Supreme Court to overturn it. That's a gamble. So I think it is a motivating factor. You'll hear the contrary from the defense. Well, they're not covered by insurance, and we don't want to consider as part of a settlement. But I think it is something that should be, on certain cases, discussed. You know, we know it's a high bar. We know that it's going to be difficult to prove at times. But I think the courts, you know, have shown a history that it's certainly a possibility in cases that punitive damages is a possibility.
Getting back to what Graham was talking about earlier, though, when punitive damages have been alleged in a medical malpractice case, it can make it more challenging to set reasonable expectations on both sides, but particularly on the side of the plaintiff, because they've heard about the punitive damages, and of course they want the settlement to be as high as possible. And if they're, you know, with the extremely high bar, it can make it very difficult and challenging to manage those expectations, to understand that it's extremely unlikely the punitives will succeed. They do on occasion, but it's not common that that occurs.
And that's true. And at the end of the day, assuming you reach an acceptable number, it's important to, at least from our perspective, protect our client from tax liability. So if this really is a settlement where, you know, we're not paying for punitive damages or aggravating circumstances, that needs to be memorialized. None of the consideration here is being paid for that. Confidentiality will be discussed later. It's important to, you know, protect our client from tax liability for that, because those are non-compensatory factors and damages, which can be taxable. So it's important to put make sure that it's appropriately documented in your mediation agreement and in your final settlement agreement.
Absolutely.
Yeah, and I think I'm glad you brought that up about the tax, because if it gets to the verdict, I've seen post-verdict negotiations where the settlement they make sure that none of that is punitive damages, so that their clients don't get taxed on it.
And that's what we argue about. You know,
Yeah.
So.
Yeah.
But setting those expectations and managing those expectations is really key and critical to trying to resolve. Bill, you want to talk to us a little bit about the National Practitioner Database and what that means to medical malpractice cases?
Yes, good morning. So the National Practitioner Database, what is it? It's a national clearinghouse of information that is collected and released that is supposed to have something to do with the competence and professional conduct of healthcare providers, including physicians. So why is the data bank important in the discussion of settlement mediation? It is often an impediment to settling a case. I would estimate about a good healthy third of the cases I've tried, 120 cases or so, I did so because the individual physician simply refused to settle a case. And most of the insurance carriers, the major carriers, have a provision in their policies that allows individual physicians to have that right. So it is important for both sides to understand the impact that can have on settling a case. So there are some nuances though that we all need to be aware of. First of all, payments by individuals. It used to be that if a practitioner reached into his or her own pocket and paid a settlement out of their own funds, that was reportable. That's no longer the case. Courts have held that payments by individuals are not reportable to the data bank. So that is one way to get around that obstacle to settling cases. Payments for sole shareholder.
Could we pause on that point? So
Absolutely.
that's one way in which resolving during mediation can be beneficial to both sides, right?
Sure, absolutely, yeah. Payments for sole shareholder corporations, that's where there's a corporate entity, but there's one practitioner who is the sole shareholder of that. If the payment is made for the benefit of an individual practitioner, then that settlement has to be reported. But if the settlement is made on behalf of an employee of the corporation, but is not the individual practitioner, then that does not need to be reported. Payments for corporations and hospitals, those made solely for the benefit of that healthcare entity, a practice or a hospital, do not need to be reported unless it's being made on behalf of an individual physician or practitioner. Identifying practitioners, a report must be submitted on a particular healthcare practitioner and not the organization. For it to be submitted for that particular healthcare practitioner, that practitioner must have been named or identified in a petition or a complaint or in a claim. But if that practitioner is not named in the petition, the lawsuit, the claim, but is included in the release, then that practitioner in the release does not need to be reported. Impact of dismissals. If a dismissal of an individual defendant healthcare practitioner is made as a condition of settlement, then that settlement must be reported on behalf of that practitioner. But if there is a reason that a practitioner as a defendant is dismissed for reasons other than the settlement, then reporting is not required. Confidential settlements, we often, almost all the time, require as a condition of settlement that the settlement be confidential to protect the professional integrity of the practitioner. That is not a bar or does not negate the requirement to report a settlement. Payments to multiple practitioners. If a settlement is made on behalf of a number of practitioners and it's impossible to apportion those payments to the individual practitioners, then they all have to be reported, unfortunately. But if there's a way of apportioning it, then that needs to be done. Fee refunds, those are deemed to be a reportable payment under the data bank, but a debt waiver is not. So if a healthcare provider agrees, you owe me so much in terms of professional fees and services, I'll waive that. That is not a reportable payment. High-low agreements, it's a contractual agreement that we all know about, where the defendant agrees to pay a certain amount of money regardless of the outcome of a trial, and agrees to pay a high amount and sets that as a high ceiling to the payment regardless of what the verdict is. There's a nuance here that is interesting, that if a jury awards a defense verdict and there's a high-low agreement, and so therefore the defendant pays that low amount, that is not a reportable settlement. The courts have interpreted that to be a separate contractual agreement that does not trigger the reporting requirements of the data bank. Finally, structured settlements, those also must be reported. The data bank interprets that to mean that when the lump sum is paid, that is what triggers the reporting to the data bank. So these are things that we all need to be aware of when we're talking about settlement and mediation.
And from the plaintiff's side, it's my understanding that sometimes the plaintiffs want things to be reported to the National Practitioner Database because they feel that the behavior has been so egregious that they want other people to be aware. Would you agree with that?
Somewhat, but
Yeah.
I'm not sure that most lay people even know about the National Practitioner Data Bank, and it's much more opaque to me than it is to Phil on how that operates. So, that's all part of discussing with your client what we can reasonably accomplish for you here. So, yeah, Erica, you were.
Yeah, and I'd say if it's a case that involves like sexual assault or something like that, police are involved or media is involved, and that is punitive enough, but that's not a case where that would really come into play. So it becomes actually another bargaining chip. We've been asked to dismiss doctors, a couple days prior to potentially a mediation, and for us, that's a good sign and something that we're willing to negotiate with if it's appropriate.
So that helps to facilitate negotiations and mediation.
It does, and that would always come along with an agreement of if we are not successful at mediation, we agree on what the next step is to bring that named practitioner likely back into the litigation.
Okay, and next slide. So often in medical malpractice, there are multiple defendants. This can be really challenging in trying to litigate and settling. Phil, would you talk to us a little bit about multiple defendants in litigation?
Well, I think it's a good practice on the defense side to see whether you can reach a side agreement before mediation among the defendants, an agreement as to apportionment and limits to what is going to be offered during mediation. If that doesn't happen, then it becomes a much more difficult mediation process, in my experience.
Absolutely, yeah. From the standpoint of settling, it can be very, very challenging. There's the recent case in Missouri here, the Setzer case, where they brought medical malpractice against the physician and the hospital related to the unborn death of a child, and settlement was made with the physician outside of the trial that proceeded against SSM. And the court found for the plaintiff, but they didn't reduce the judgment by the amount of settlement with the doctor. And this caused the case to be remanded and go back to the courts. And it ended up being a very long, drawn out process, which had they managed to settle with both sides, the family would have gotten that closure. As long as the litigation is continuing unresolved, there's emotional turmoil for the family, the defendants, the costs escalate, and sometimes there are contractual arrangements between the physician and the hospital, which can further complicate trying to settle, when there are multiple defendants. Have you had experience from the plaintiff side with multiple defendants and how that's impacted settlement at mediation?
Certainly, and as Phil said, a difference between the various factions on the defense side really does make it more challenging. But at the end of the day, you still try to reach, what's going to make a sensible outcome or not for the client. And So if one defendant does not want to settle, they need to understand what settling with a group or one individual defendant means for them, even if they get their best day at trial. You know, there's going to be the statutory provision for them to get credit for, you know, the amount of the settlement. So it's all helping that client understand what's the monetary and benefit and benefit otherwise of either doing it or not doing it.
Yeah, Phil, I believe you had a case some years back where there were multiple defendants. This was an Illinois case. And they settled with part of the parties and the case proceeded to trial. And the plaintiff had been reluctant to settle against the one physician. And defense was willing to come forward with an offer. And the plaintiff insisted, and there was a finding for the defense, and the plaintiff was very surprised by that because the defense had come to the table at mediation willing to make an offer. Do you want to talk a little bit about that?
Yeah, well, it was a bit of guts poker on the part of the defendant to take that position and take the case to trial. Now, in Missouri, what would happen if there is a defendant who doesn't settle and the case proceeds, then that defendant has a choice between contribution, that is submitting to the jury at trial a claim against the settling tortfeasor versus a dollar for dollar set off of the amount of the settlement proceeds, and that's what the Sessor case was all about.
Okay, next slide. Just kind of non-economic damages. I believe, Bill, were you going to talk about non-economic damages?
Well, this is a damage item that we always struggle with before settlement mediation to identify what is the value to the family of the loss of for example, in a death case. How do you put a monetary amount on it for purposes of settlement? What is the range that we think is a reasonable amount to pay the family for the loss of a loved one or for an injury? So we often use different tools before settlement to come up with those kinds of amounts to consider in settlement.
It can be very important to the families to know that there's something being done to prevent future harm, and making policy procedure changes or medication administration practices being changed. That can go a long way towards trying to resolve a case when the family knows, because true medical malpractice is never going to be remedied with just money. It can't be. And sometimes it can make a big difference if the defendants are willing to make policy procedure modifications. Many times they're not willing, but that can be very key.
So on the slide there, the point number 2 about apology, it used to be that in mediations, parties would give opening statements. That seems to have fallen by the wayside, which I think is regrettable in some situations. Because when I am given the opportunity to give an opening statement, particularly in a death case, it gives me the opportunity or my client representative to give a heartfelt apology or sorrow to the family about their loss, because that is something that has really affected their lives. And I think that, first of all, is the human thing to do, the kind and humane thing to do. But I think it also helps, resolve some of the tension that might be there between the aggrieved family and the defendants.
I think that at opening statements, it can be very helpful to have just a very brief statement that acknowledges the sorrow or the loss that someone has suffered without admitting fault, of course. But a brief statement can go a long way towards trying to move towards negotiations and settling. Final slide. Just some final tips and takeaways. as we've heard from all the participants here, prepare your clients, prepare the mediator, prepare your documents, listening, and that's primarily listening to the clients, for the mediator to listen very carefully to both sides and allow them to be heard, but also to have the clients be able to hear what the mediator is saying so that they can set reasonable expectations and move towards resolution. Best case scenario is only 80-20. That means there's still a 20% chance that your case is not going to win. Explaining to you want to say
Yeah, I
something?
think
Go ahead.
the gloss on that is that there's some research that shows that that number is variable depending on the strength of the case, 50-50, sometimes more, but every case is individual. But those are the things that you want to make sure your client understands.
Absolutely, and I've gone to mediation where the plaintiff side and or the defense side, they've not had brackets and midpoints explained to them prior to the mediation. And having prepared your client for what brackets are and how people look at the midpoint, even when you say it's not the midpoint, you're still going to be looking at the midpoint, and having them prepared to understand what that means and to go into it recognizing that the other side is going to be very far off, because you never give up on negotiations. You have to keep at it. Graham said nothing gets done till 2:30 in the afternoon. Sometimes it doesn't get done that day. It may get done a day or two later at the end of the day, and you want to never give up. Did anybody else have some closing comments you wanted to make here? Our time is up. Do we have any questions out there?
We do not. And as I mentioned earlier, folks, if you have questions, Ellen has agreed to receive those from you. Her email is here, and then she'll forward those to the panel and get answers for you. I want to thank Ellen, Erica, Graham, Phil, Steve. This was fabulous, and the breadth and depth of your experience really shows, and giving of your experience and your time in preparing the materials and speaking with us today. A great program and great discussion. And folks, take a look at the materials again. A couple of those cases that are recent are certainly relevant to those who practice in the medical malpractice area. We're going to take just 5 minutes and then get started with our next program. Thanks.
Thank you.
Thank you.
Thank you, everybody.
Folks, we are going to get started with our next program. For several of our seminars, based on your comments, because of the hot issue of insurance coverage disputes, bad faith, we have covered this periodically, but at this point, it just seems like shifting sands, and we have two outstanding presenters today. So Mike Young, Reichert, Nose, and Young, primary emphasis is in this area: insurance law, bad faith, representing insurers, both in complex coverage and extra contractual matters throughout the claims process, Missouri, Illinois. Mike's also an adjunct at St. Louis U Law School, teaching a course in insurance. Chris Finney, St. Louis U Law School, started his trial practice as an assistant circuit attorney, experience in handling bad faith claims, collecting extra contractual damages, and has had numerous multi-million-dollar verdicts from the plaintiff's side. So without further ado, Chris, you're going to get started?
Yeah, Rob, is my screen showing?
It is.
Okay, great. So I'm on my iPad here, everybody. So stick with me as I'm out of the office. But I'm going to start with the plaintiff side. And as you'll see from the slides, mine has much less case law than Mike's, which probably explains the plaintiff first defense side. But I think they work well together. And Mike and I had talked yesterday about a 2022 case that had come out that we had some interesting conversations and feedback about. So we should play well off each other. And then obviously if questions are there, go ahead and throw them in. And Rob, if you see them, let me know and we'll address them.
Will do.
I think you hit the nail on the head, Rob, that this is a topic that is coming up. In fact, I had a mediation yesterday involving an extra contractual case where it had to do with the demands going, or the settlement offers going back and forth and releases and things like that. So to the extent that I can, I'll try and share some discussion from that as well as we go through here. So when you, on the plaintiff side, when we intake the case, and I've seen the participants here, we've got some very esteemed lawyers here who this might be watered down for them, or who knows, they might have different opinions. So feel free to share. The number one thing that when you intake the case is, you know, as you're gathering the materials, when is the case ripe for demand? When are you going to send it? Sometimes if it's a low policy, it might be ripe very early. And you want to take into the considerations for that. Do you, as the plaintiff side, know enough to make an offer to resolve such that you're fully informed as to what you're doing and the other side can be fully informed? So there are things you need to take into account there. Stickler versus McInnes is a case that Mike is going to talk about, I think, a little bit, at least it's in there. There's also some, I guess, gold standard insurance coverage cases and bad faith cases that Mike has as well, which we can talk about. If you're going to make an early demand, are you going to make it subject to 537058, which is your time limited demand that more and more, I think, at least from what I'm hearing, the plaintiff side is trying to utilize more. It just does, it requires some, I think, some onerous activities on behalf of the plaintiff to get set and get organized. Now, there's good and bad to that. If you do one of those, it does seem to catch the carrier's attention a lot sooner, and with, I guess they put more priority to it when they see that. It also allows you as the plaintiff, you're going to get a lot of things in order right off the bat, which is, you know, if someone's making you do your homework, that's better than you imposing your own homework sometimes. So I think that there are benefits to it. You also want to make sure when you send this, you know, does the carrier have the information they need? Are you allowing them all the time they need? Are you putting a time, a 90-day limit on it? Are you following the statute? Or is this something that you're throwing out there for them because you think it's pretty clear cut? These things are going to kind of run together, because you may, in a catastrophic case with a low limit, is probably the case we're mostly talking about here with this situation, is you're more likely, I think, trending towards filing suit and discovering what's there. You know, again, the Stickler case is a good example of maybe not having to file suit and trying to obtain some information. If you have a catastrophic case with low limits, we've had success in the defense agreeing to produce a statement under oath by their insured to ensure we've got everything covered. We treat it like a deposition. It's under oath, and you can find out, you know, maybe there's some ancillary coverages out there that you haven't seen. So you may not have to file suit and do discovery if you've got an agreeable defense counsel on the other side or adjuster who agrees to send it out. But if not, you might have to file and start moving, because you're going to need, you know, we need that testimony or documents to find out whether this is ripe to make an offer. And as I said before, sometimes, you know, you don't need everything. If it's a catastrophic case with a low limit, there are pretty clear indicators that this is a policy case, and you want to make sure now you're going to move to how are you going to resolve the case so that you've covered your bases and the defense can cover theirs. We have, unfortunately, we've gone away from sending anything by the United States Postal Service. I don't know about all of you, but they tend to get lost. And so we're trying to do certified mail, which is still Postal Service, or FedEx. You need some kind of documentation that it was received. These days, as everybody knows, there are scanning centers where these documents are all being sent to a scanning center. They may or may not make it in if you're sending paper mail. In the last year or so, I've seen more and more carriers allowing email uploading, depending on how big your case is. And that's a good way to confirm that they've got it. We always follow up with at least an email of the letter, so you know everything's covered. They received it one way or the other, and you've got a variety of ways to cover your bases. So when considering how you're going to settle this matter.
Hey, Chris, I'm
yeah.
sorry, I don't mean to interrupt, but I just thought that was interesting because from the insurance company perspective, what I hear a lot of times is, oh, a settlement demand has been made and we just don't have enough information. You know,
Yeah.
you know, they've sent us this, but we don't have enough. You know, what is your perspective? But what are you seeing from insurance companies? Are they just using that in your view as an excuse, or what do you?
Well, that's a good, you took the words. I don't like to see the bad in everybody, but I will say sometimes we have to have reasonableness here. And so that's, I think, the biggest factor is when cooler heads prevail when it's reasonable, because we all have been in a situation. Maybe you've seen this too, Mike, when you've gotten a file after this has happened where, hey, you really didn't need the driving record or whatever it was you were requesting that's ancillary. The poor individual had their leg chopped off and it's 100 policy. Depending on how you move up, it's more of a gut check. Do I feel, based on if this went further and a judge was looking at this in a motion for summary judgment, that the carrier had enough information? And that doesn't mean I'm going to hide information, but we've seen more carriers say, hey, we want everything in listed in 05A. Well, we don't always have that right off the bat. And I don't think that's the law. And so that's the rub we're getting is, hey, you need to give us wage loss. Well, we don't claim wage loss. So why do you need it? You know, stuff like that. We don't have it. We try to give them everything we have. We usually do give them everything we have. Just depends what we have and whether we believe in good faith, reasonably, this is plenty to decide this case. Yesterday, we had the mediation that I talked about. Obviously, you weren't involved, but it was a minimum limits case, and we had given, I don't know, a couple thousand pages of medical records, and we were still getting letters requesting more and more stuff. And at that point, things had become contentious. And it was like, hey, this is an open and shut claim. We believe they did not believe it was. And we had some issues, and I'll get into that later. But that's where it gets to be where we think one side's being unreasonable. They think we're being unreasonable. Usually it's cooler heads prevail, we hope, but it can get sideways, depending on what the request actually is. So it's kind of a nuanced game.
Yeah, because when I've seen it, sometimes a demand is made, and I'll agree with them. Like, yeah, I don't know what this thing is worth. But on the other hand, you see some cases, it's a 2550 policy, and the damages are clearly exceeding that. And like, why are we asking for all this stuff?
The perfect example would be an airlift, right? You have an air vac from a scene and it's a clear liability. Somebody got airlifted. We all know that company is going to have at least an 80 to 90 or $100,000 bill. Well, do you need more coverage or more information beyond that? Probably not if you have a 2550 and it's one individual involved. So those are the open and shut ones, but there's definitely a lot of gray area, which is, kind of a judgment call as to what's needed and what's superfluous.
Yeah, it's so funny because I think for a lot of the adjusters, they have this notion, goodness, I have to document my file. I have to have all this stuff here. And, maybe in some jurisdictions that's fine, but in a place like this, that's the balance. Do you really need all this depending on what the limit is?
Well, and that's true because you have the adjusters doing multi-state adjusting. They've got different regulations, laws they're looking at, which
100%.
leads actually good into the next slide, which is, what are you actually presenting? What are the claims you're presenting? And you might have, your best claim may not be covered, but you might have a claim that is covered, and that would trigger coverage. So you need to have something that is going to trigger coverage for the carrier if you're making a demand. If you're making an offer to settle and nothing's covered, it's almost not worth the paper it's written on to the carrier. It has to be an actionable, good faith coverage claim. Can't be forced, can't be concocted to hook coverage. But as we look at these policies, and a lot of times you don't have the policy, but you can either get one off the Department of Insurance website, you have an idea what's covered. You can look to see what's covered. I know you and I talked about first aid coverage yesterday, and how that's kind of going away because it was just too nebulous. It was impossible, and it was leading to some pretty interesting litigation. So it's good to have the policies to know what you can present as a covered claim versus what is not, and at least get one covered so you can go from there.
Chris, do you get pushback from carriers when you ask for the policy?
Yes, tons. And that's a serious, I don't say tons, that's not fair. 50-50. It depends on the severity of the case. The more severe, the more pushback we get. And maybe you can answer this. I still don't understand if an item is discoverable, in a standard request, what is the rationale of withholding it? It's almost an enticement to file the lawsuit. And so what are your thoughts on that? Do you know the rationale behind that? Varies carrier to carrier. What are your feelings?
Yeah, I think it depends carrier to carrier. Some of them have a view that we don't want to turn this over unless the insured consents to it, that this is somehow their private information. And if we don't get their consent, we don't want to do it. Some of them will just have an internal guideline. We don't have to do it unless the law requires it. Because we'll get questions. Hey, they've asked for this. Do we have to turn it over? And, there's nothing in Missouri, as far as I can tell, that requires it
Correct.
pre-suit. But like you say, okay, well, now you're going to sue our insured and you can send over a request for production, and Missouri says what it says. So are we just drawing a lawsuit by doing that?
Well, and I think it does vary, even adjuster within carriers. I've seen some who will turn them over, but the more important point with that is in this slide is the working with insurance. If it's kind of a give and take, and if I'm giving something to them, maybe I'm sharing more medical than I need to, or even maybe I'm sharing 20 years back. I would expect a little bit to come back towards me, which would be in the shape of, hey, I know you don't have to give me the policy, but I'm trying to facilitate an open discussion here to see if we can get this resolved. And when you don't get something coming back from both sides, you just don't set the table for what I would call a open and honest conversation about what's going on, because there's a lack of trust. So you need to kind of step back and say, all right, do I have something that I need? Do I need to get it from them? How can I work? Am I giving them everything they need? And the most important part is going to come into what's material. And I think we've kind of touched that on a little bit about what is material. We may talk about Stickler versus McInnes, where maybe it's, what's material has maybe been watered down. I don't know. I was talking to Alex in my office about that as well yesterday, and he had a different take. So we'll get there. But overarching theme for all of these opportunities to settle is the clarity. And these are my best ChatGPT legal clarity images that showed up. Who are you releasing? What are the claims that you may or may not know? What other parties could be liable? Has to be in writing. Some people have ideas of, what are the non-monetary items, the medical bills only. The overarching ideas, ambiguities can lead to a lot of accusations of bad faith and unfair dealing down the road. And what I've seen on my end, and it happened yesterday, which was maybe the broadest release we've ever been given, is that releases seem to get broader and broader and include individuals we've never heard of or seen before. And so that is why we've tried to send, and I think a lot of people may do this, a release with your offer to settle. So we're all on the same page. You may have John Smith under your policy somewhere. I don't know who John Smith is. I don't know if he's involved. I don't know the relation. Maybe I don't know enough information to settle this case, but I am offering to settle a case against Mike Young for his liability arising out of this incident, and he appears to be an insured. But I've got him in there, so maybe I'll settle with you, and then I get something back with 3 or 4 other names. Now I'm wondering, what other claims could be out there? Do I need to litigate this to find out who these people are? Are these parents? Are these friends? Or are they the actual insured in the policy and Mike Young's a permissive user? What's the relationship there? Is there additional coverage that could have applied if, this driver gave them this car? Is there another policy on the actual driver? Things get a little fuzzy. So it goes back to the timing. Are you in a position to settle a case if you don't know this information? I think a lot of times we're not in the position we think we are to settle a case because of these unknowns. And, let's be honest, 95% of these unknowns might mean nothing. 99% of them might mean nothing. But I think there's situations where you have catastrophic harm where it's in your interest. It's not even in your interest. It's your ethical duty to run all of this down instead of taking a quick 100 or a quick 25 or whatever it is. I think you really have to dive into all of this work. And on our side, the plaintiff side, it may not be monetary income for you. You might do a bunch of work and not realize it, but that goes in the ethics of the practice. And when you signed up with the client, what were you going to do for them? You want to make sure you run down everything in a catastrophic case. I will
Yeah,
say the releases have seemed to have gotten less and less over the years to include all persons known and unknown. Those have gone away. They used to have those, I think. Mike, are you still seeing those? I haven't seen a lot of them, but
Not-
they're replaced with just like 7 names now.
Yeah, you know, the problem, like I see in my cases, is one of them you mentioned, you know, that there's the permissive user. Are we going to get a release for the owner to knock out the negligent entrustment claim? In a trucking case, maybe we insure the truck. If you read the policy and hold it to the light just right, maybe we insure the trailer too. So do we want to get the trailer knocked off? Do we have additional insured issues on the construction site? Oh my goodness, we have the general, but maybe we have this sub or vice versa. And the worry that I have is that if the insurance company doesn't at some point, without rejecting a demand, talk about that with the plaintiff, if we go too far down that road and now you and I have agreed on a number and we think we're done, and I'm like, oh, by the way, I need the trailer release too.
Yeah.
Now we got a problem. And Rob can comment, you know, on that, like during the mediation, like, when do we introduce that? You know, like, oh, by the way, Chris, I need this guy released too. You know, and you're like, wait a second, you know, that it's a real issue, I think.
And that was what we were going on yesterday at the end of the mediation. There was a lot of well, I spent a lot of time sitting by myself, which is normal for me, I guess. But there was a lot of discussion about who to include. Now, we had identified all the parties and things like that, and everything was good. But prior to that was the issue, was the original release, which did not have all these names on it. Then names started to appear, which we were unaware of and couldn't get answers to who they were. So there is a lot of that. And I think the release language being, again, clarity, right? The clarity of who's included and why. But to your point, bringing up, you know, hey, there are other entities that could be here, and you know, we need to get them on there as well. Even though negligent entrustment cases are fairly difficult to prove, it's still an open claim that needs to be resolved, that could be hanging out there. And that is a number one issue we see on these 25-50 cases or whatever, where, you know, it's a friend borrowing the car, or it's a mom got it for a teenager or something like that. So
that's right. And then the release comes over and all of a sudden the owner's on there and no one's ever talking about it.
And they may not even have the same name. And you're like, who is this person? You know, I don't know what is, you know, so did they hire them? I don't, you know, who knows? The other thing in keeping with the point of clarity is, at least on our end, you at the plaintiff's side, you really want to have one person who is handling the negotiations and the release language. Having more than one person, you know, turns into a game of telephone. And, you know, to say, oh, Mike called and he talked to Alex, and Alex tells me what Mike said. Oh, no, that's not what was said. There's no way. And even I think Rob could talk about this too. This happens in mediation. You know, they will say, one side will say, we need so-and-so, or the message will be, we absolutely need so-and-so on the release. And one side will be like, no way. That's not even a person we've looked at. When you talk to each other, that it comes clear, well, we weren't that strong about it. Okay, well, you know, I mean, things get kind of muddled if you're not absolutely clear, which is why I prefer to have these all in writing. Even the acceptance, I know that the practice seems to be that the carrier will call. It's almost like a soft call on a catastrophic case on a low limit, soft call to feel out, hey, what's going on? And a lot of those times I end up with more questions than answers. And I don't like that when they call and they're very cagey. I think they're cautious. They're a little nervous. It's about what's going on, because it might be a large loss and a low limit. My practice is, I don't really know what, just please send it in an email, send it in a letter so I can evaluate it, because we're going to get sideways on who's saying what. And then down the road, we could be witnesses or whatever it is. I just would prefer put it all in writing, and then we can go from there. But the soft call seems to be more and more of a play. Have you seen that in your guys before the case gets to you, or is that a practice that the adjusters are implementing?
I do think it is a practice, and I think, at least in Missouri, it's probably by design, you know, because Missouri, you know, the Stickler case, you know, that we mentioned, you know, carriers are, I think, rightfully paranoid about doing something that's going to be seen as a rejection of the demand, right?
Yeah.
Because once we reject a settlement demand in Missouri, that may be it, you know, and now we're off the races on a bad faith case. So a lot of times there may be, you know, some hesitation to put anything in writing because they don't want to make an exhibit it can be seen as a rejection. I mean, On the other hand, I've seen people email stuff and I'm like, man, I wish you wouldn't have done that. You know, you just called. But
Yeah.
I think part of it is that, Chris, they're trying to see if we can resolve it, but they're just scared to put anything in writing.
So is at that point, and we have done it sometimes where we've requested, can you send this out to counsel? I'm not sure what you're saying. A plaintiff should not be afraid to make that request. The carrier's usually amenable to that. They'll usually say, okay, we'll assign it out if we've got too much going on and we can't come to an agreement. However, it could be, I'm just speaking candidly, is maybe not be in the plaintiff's best interest to be dealing with someone like a Mike Young, who would, say, whoa, guys, this is going sideways, and try and get the train back on the tracks. So, the clarity is the key. The soft call is a practice. I know they're very worried about that, but it does make me nervous.
Yes.
Because I don't really know what they're saying either when they call, and I don't think they have a clear direction. They're trying to feel you out, and then was like, well, no, I just want you to stick with what I wrote. What did I send to you? Well, okay, well, we talked. I don't remember. No, I don't have a great memory of conversations, so let's stick to the writing, and that's the practice we try to implement. I think that's best for both sides, because I think the soft call is one of those things that have just kind of muddied the waters more than it provided clarity.
Yeah.
And it leaves too much subjectivity.
It's an interesting perspective, Chris, because that you would say you'd rather not have a lot of phone calls. Let's do it in writing because we don't want to get crosshairs on what we're saying to one another. Because I think sometimes on the insurer side is, oh, he doesn't want to talk to me. That means he's trying to set me up. That's where they're going a lot of times.
Yeah. And there are either way, no matter what happens with these, you're going to get accused of a setup. But at the same time, it happens all the time. But what you're trying to do is, I don't know what I don't know. And if I know that an injury is catastrophic and a policy is there to cover it, and I can get my individual something quickly and move on to some other stuff and look at other entities, then I'm going to do that. I have an obligation to try and figure out how I can get them without hurting their case. So that's a lot of the reasoning behind it is, all right, I'm not trying to settle this case into all, but I would release you as long as you're not an agent of somebody, and so, and there's nothing else that applies. And it looks like there isn't, so I can go forward that way.
Right. Because you can't settle a case for these other people without knowing what they have.
Exactly. And, sometimes there might be an MHTC case out there that you're not sure what's going on there. You may not know if they were, the biggest thing in a gig economy is you don't know who they're working for. I think even now I had a case I came across that had already been settled for the principal or for the agent. And it might have been, they were driving for Spark, which I think Walmart had Spark as like their delivery service, maybe for a little bit. I'm not. And so, but there was a trader's policy on it, and somebody had settled the trader's policy without looking into, and had released the driver without looking into the Spark aspect of it. And they're not driving cars that say Walmart or Spark on them. You're not really sure what's going on. The more and more we have Uber, the more and more we have Uber Eats. You have all these things, Grub. I think it's Grubhub, whatever it is. You have to really take your time before you start releasing everybody, which I think is lending itself more to, you got to do some discovery, or at least get somebody under oath. So that's my spiel, I guess, for the plaintiff side of it. And I guess I would turn it over to you because you've got the bulk of, I think I got to stop my screen share somehow. You have the bulk of everything when it comes to the case law. So let me see if I can get back to the Zoom.
See if I can.
And I should be stopped now.
Very good.
Can you guys see that okay?
We can't. Mike, we did have one question that popped up when you all were talking about not maybe knowing all the identities of who needs or should be in the release. What happens when the release document contains a confidentiality provision that had never been discussed either in negotiation or mediation, but it shows up in the final settlement agreement? How do you all deal with that?
I'd like to jump
ahead,
on that
Chris.
one, Rob, because that came up yesterday.
Okay.
And it was a very, and I'd like to get Mike's perspective and yours as well. It was a very, very broad as to basically, the other side wanted me to submit a written proposal about what would be said that they would approve, that they would have the final say on. And I said, no, I'm not doing that. I mean, that's, because it comes into, you start to run into the ABA Rule 5, 5.6, and that's a lawyer's right to practice law. And there are some papers out there are some opinions out there that say, hey, confidentiality, blanket, and very strong confidentiality can inhibit a right of a lawyer to practice law, to say, hey, I practice this type of law. I have gotten, this is my experience in it. If you inhibit them and say, hey, I don't want you to put that anywhere on your website, even without names of parties, case numbers, anything, that to me it gets to be, as I said earlier, these overly broad confidentiality agreements. And to me, confidentiality is a material term. I think Stickler is kind of leaves it to us now to almost define what a material term is. I don't know if I'd go that far, but you have to make clear, and I don't think I said it in my slides, what's material to you and have a good reason for it. I'm not a fan of confidentiality. I understand the rationale behind it. I am a fan of it when my client says, hey, I'd prefer this not to be out there anyways. And that's in the interest of my client. More often than not, they do want it, in my experience, the clients do, when you explain to them, hey, this could be out there. I don't know if you want your cousin Jimmy, who's your sixth cousin, seeing this and, running case net and seeing what's going on, seeing your case settled and wondering how much it was. So I don't know if Mike has a different view on that, but I believe confidentiality is a material term. And too often, Rob, it does show up at the end. I have seen a trend, though, mediators have started with that, with the opening offer, with
Correct.
that. Yeah.
That's exactly it. Because at the very end, I come back and the defendant says, all right, our final offer is X. Plaintiff says, yes. Defendant says, and we need confidentiality. And sometimes it's the plaintiff's lawyer says, okay, now how much more are they paying for the confidentiality?
Yeah.
And when we bubble that up at the very beginning saying, look, we're going to be trading numbers, but confidentiality needs to be part of it. And at some point, we'll talk about what that means. Does it allow you to have the venue, no names, no name of the carrier, maybe even the lawyers, but it can say you had a settlement in the amount of X. Okay, because sometimes we're mediating what you're able to do in terms of just disclosure, but it's much better to do it and bubble this up early on.
Yeah, from my perspective, if it's a true bad faith case, usually I don't get a lot of no's, from the plaintiff and insured bar on confidentiality, because everyone kind of knows, look, if it's bad faith, we're probably paying above our limits. The insurance company doesn't like that out there. And the players that handle those cases usually understand that if it's an E&O case, medical malpractice, a legal mal case, we really need those confidentiality. You get, sometimes in car accident cases, they're like, no, we're not going to do it. Sometimes abuse cases are some of the most difficult to ask for confidentiality, right? Because it's like, no, we're settling this case and we don't want to be quiet about what we're settling for, And so in employment discrimination cases, we get, we've had a few employment discrimination matters where the fight at the end of the day was really about confidentiality. It wasn't even the dollar amount so much. And so I think you're right. It's one of those things that we have to talk about in the debate. It's sort of like who's being released in my mind. At what point do I introduce that in the discussions? When we're so far apart, do I need to say it? Maybe, maybe not. But at some point I have to, because you're right. We don't want to be at the end of the day where the final acceptance turns on that. Or like Chris is saying, worst case scenario, we have a deal and now all of a sudden people are talking about confidentiality and was never discussed. And it's one of those things, I think, from the insurance company perspective, that sometimes people don't think about until it's too late. I've had cases, where people have tried to, we wanted to settle. And as we get towards the end, or sometimes even afterwards, the insurance company says, well, all our settlements are confidential. You should just know that. I'm like, really? Well, no one told me that, and now we're in a mess, right? Because now I have to call Chris and beg, for confidentiality because no one even wanted it, said it, but now all of a sudden we have to have it. So, I agree. It's I mean, I think it's material term too, and it's something we have to get out there.
Absolutely. Thank you, guys. Mike?
Okay, so maybe we'll go ahead because I had some initial slides here. Maybe we'd get back to those later, but I think, the one that we were talking about a lot, Chris, was this Stickler decision, right? This is something out of the Western District from just a couple years ago, and it's the so-called mirror image acceptance doctrine, which really gets into, I think, a lot of the paranoia for why maybe insurance companies are calling you, Chris, instead of sending correspondence. It's this notion, and it's basically just contract law 101, right? That if you have to have an offer and you have to have an acceptance on material terms in order to have a contract, right? And so the notion is, if there's a settlement demand with certain terms, the acceptance has to mirror that, in order to have a deal. And if the insurance company responds to it with anything other than a mere acceptance, that's considered a counteroffer. A counteroffer is a rejection, and rejecting a settlement demand in Missouri could have consequences, right, for potential bad faith exposure. And so for the longest time, Missouri has always had this doctrine that, well, if the other side responds to a settlement demand and they introduce new terms, but they're not quote unquote material terms, that's not really a rejection, right? And so the Stickler case out of the Western District had this line that I have here in bold: any acceptance that includes new or variant terms from the offer presented amounts to a counter offer in a rejection. So that language is different. It doesn't say material, it just says new or variant. And what does that mean? Now, I think the case that it cites for this proposition is a material term case. So has the law really changed or not? I don't know. But again, when we talk to insurance companies about, responding to demands, like, you got to be very careful with this sort of thing, because, I have a slide here, sometimes the settlement demand may have all these different kind of things, right? You have to accept by a certain deadline. I need a release by a deadline, payment by a deadline. The payment has to be to certain people. I may need an affidavit from your insured saying they have no other insurance or assets. Like Chris is talking about, I can't release, without knowing the universe of coverage out there. Maybe I want to see the copy of the policy, the affidavit of the insurer. If we're not saying on the insurer side yes to all this, is that an issue? And sometimes the terms in the demand, when I read them, they're not clear, what I'm saying yes to, and so that's where I think I've advised people, that's when the phone call, or if they don't respond in an email to plaintiff's counsel saying, hey, you say you need an affidavit of the insured, what does it got to say? We'd like to accept your demand, but right now I'm confused. I don't know, what you need there. On the other hand, the insurance company may want to have other things in order to have a deal, a release of additional claimants, then is set forth in the initial demand. Maybe I want additional insureds release, different parties. As we talked about, I want confidentiality, the indemnity. I want your client to indemnify me for anything rising out of this settlement. Here's a big one: liens. Insurance companies are obsessed with liens and who's going to pay these liens, particularly Medicare liens. None of this may be in the settlement demand. If an insurance company responds and says, yes, I accept your demand, but I need these bullet points here, arguably that's a rejection of the demand in Missouri, and now we're off to the races. And so I've always felt like it's a good practice, clarify this stuff. Don't just shoot out a response, and you may just lose control of this case if you do that. Let's call the other side, let's contact them and clarify these things. And the reason for it is a case like Stickler, because if we do anything other than say yes, there is some risk to it. Chris,
Mike, along those lines, what, in your opinion, what is the insurer's duty to disclose to the plaintiff side additional insureds, or is there one? What's your thoughts on that? Because obviously we don't know what we don't know. And you guys, or the carrier, has a better idea who's insured. And if we just have a crash report or whatever, we've got one individual, it might not be the best. It might say SAD on it, same as driver as the owner, and who knows who's the insured. Where do you fall on that? What do you advise the carriers to do when, hey, there's like 2 or 3 more insureds on this policy? We probably should get releases for them. Do we disclose that?
Yeah, I think it and it depends. If you have multiple insureds and not enough policy limits, right? What do you do with that? And there's not a lot of Missouri case law on that. Frankly, I think there's maybe one case, and it suggests what the insurance company ought to do is to try its best to get all its insureds released. And if the plaintiff says no, then maybe you can make a decision to just get some of them released, because it's better to get some released than like none of them released, right? But you at least have to, I think, make that initial run at trying to say, hey, can I get these other people released? But the problem, so I think Missouri suggests that, but the problem is it also has this. It also has stickler, so if they come out of the gate and say, no, I have to have these 3 people, that's a rejection, right? And maybe it's not a bad faith rejection. We won't know until a jury tells us, but it's a rejection nonetheless. And so how do you approach that? And that's why I think that communication and making a record of that communication is good for the insurance company, because they're making a record that they tried to do what they were supposed to do. Maybe it worked, maybe it didn't. But if the whole thing falls through, they have an explanation that they can give a jury in a bad faith case. Here's why this deal didn't get done. Chris made a demand for insured A. We pretty much knew we had to get A and B. We asked him, would you do A and B? He said no. And then we made a decision to settle for A or not at all. And that's the tough decision they have to make. But at least they've made that record of it. But if they just fly off and say, you ask for release of A and we say, okay, we accept, here's the release A and B, now we're off to the races.
Mm-hmm. Yeah.
That's how I see the problem with stickler. What do you, I mean, Chris, when the insurance company may call you and say, hey, here's these things I need, are you guys receptive to that? Or
well, I'll say this, they're still working out the script for their call. It varies more and more. Usually I'd say 50% of the time on that call, I'm like, what are you even asking like me for? And it devolves into, why don't you just see what I mailed you guys? Like, I think those answers are in there. And it seems like they're not really on firm ground as to what they're seeking. Now, some of them are. Some of them call and say, hey, if somebody called and said, listen, there's actually the mom is an additional insured. I'm not rejecting anything, but I'm telling you, I'd like to get the mom released. Is that something you are willing to consider? And there, that soft call might work. Rarely does. I don't think that's ever happened. What I usually get is a counter with a few insureds on it that I wasn't aware of. The issue you run into is sometimes the case isn't of a value that justifies, or hey, oh, that's ridiculous, I'm off to the races. So you're probably, it works for an adjuster 80-90% of the time, and
right.
Even though they're not supposed to do it, but the habit is there because a lot of the claims aren't where they're exceeding the policy, and it's not really an issue because the value is not going to be there. They fall into that routine where it's like, oh, they sent me a release, I'm sending them mine, or you get a call, say a paralegal from the plaintiff's firm calls and says, hey, what's the deal with this case? Where are we? Oh yeah, I got a release for you, and they rush and send one out, and you're like, whoa, hang on a second, that's like 4 pages long. I didn't send, that's not what
some
we
form
sent.
release with all kinds of stuff in it.
Correct. Yeah, that may not even have the right dates or name. Who knows what and so there's a lot of that going on. But I think part of the reason that these issues happen is 90% of the time you're fine. It's on the margins where there's going to be an issue of a catastrophic loss, and that's where we try to be very clear. Here's what we sent. And I will say this, we're usually sending something that a carrier has accepted before, has used before. And because that gives us a better basis to say, hey, you're objecting to this. Talk to adjuster, Stevens. A month ago, this was signed and returned in like a day. So what's the problem here? That runs into, some, adjuster mechanics, how they're training, things like that. Maybe Stevens shouldn't have done that. I don't know. But there's a whole bunch of variables, but it's on the margins of the cases. And that's where the issue comes in when you've got these adjusters working all these different claims in different states. Now they're maybe a little bit behind the 8 ball and then rushing, and haste makes waste. They send something out that was not well thought out. They didn't review the claim file all the way through, maybe didn't read the demand as it was laid out, and now
Right.
they've got themselves in a bind.
Are you mentioned sometimes you'll say, American Family, just hire outside counsel,
Yeah.
so we can, are you more receptive when, when there's things like this, we want to clarify something, or the insurance company has to have this stuff, like the lien thing is a big one.
Yeah.
Are you more receptive if that call is coming from outside counsel
Yes.
than from the
Yes.
carrier?
And the reason is, one of the reasons is pretty straightforward. I know when the carrier when an adjuster starts asking about these things, they don't have a whole lot of maneuverability, right? They're either getting me to agree to these things or not. There's not a lot of gray area. Outside counsel, whoever it is, has the ability to work a little bit more with these terms and with the plaintiff's lawyer. Usually when a carrier calls me and asks me for these things, I know it's a yes or a no, right? It's either I'm taking it or I'm not taking it. That individual on the other side has very little room to make accommodations for these types of things, as opposed to if it gets to your office or somebody else's, and they say, listen, let me talk to the carrier. They may want these in here, they may not, but let's put a pin in this for right now, and I'll call you and we'll get on the same page, because I want to make sure I'm doing what you want, and we're doing what we want, and we meet of the minds. So if it comes from outside counsel, it's a much easier conversation, because I feel like the constraints aren't there. You have a little bit better grasp of the law, the discussion, as opposed to it comes to an adjuster, it's pretty tight. It's a yes or a no.
Yeah, because sometimes I'll get a call and they'll say, look, I've called him and he won't do this. He won't put this person on the release, or he has to have this language. And like, he's completely unreasonable. You give him a call, and so I'll call the other side and we'll talk, and like, oh, that's why you're doing that. I get it. I may not like it, so you can call the adjuster, like, look, you may not like it, but here's the rationale, right? And
Yeah.
they're not going to budge on this. So you have a decision to make. Are you going to do it or not? But here's what it is. That back and forth, I think
Yeah.
we at least get a better understanding where the other side is. Okay. Any other comments you have on that, Chris, on this?
No, and I do think the liens has become an issue, but I don't think, the liens is also variable, right? Some carriers will take an email from me that says, hey, I'll indemnify. I'll take care of the liens. My client will take care of the liens. Others want to be much more severe, and I guess that has to do with that's a byproduct of their experience, whether they've gotten burned. I don't know, in all the years we've been doing it, rarely have I ever seen a carrier get dinged on a lien. I'm sure it happens, but like in all our cases, and we're, by no means are we doing this the best of anybody. I've never seen a carrier calling back and say, hey, there's a lien on this that you guys didn't take care of. I know that it happens, but I also think it may be I won't say overblown, but oversold problem on that, because it's like an anecdotal story. I didn't get a Medicare release or lien release on this, and it was $95,000 on a $25,000 case, and they attached it to the carrier, and now we're all screwed. I don't know how often that happens, but you know better than me.
Medicare is the big one that they worry about the most, right? Because they've attended these webinars. We're like, oh, if you don't take care of Medicare, we're going to get fined $800 a day for the next 35 years. And like we're going to burn the insurance company down if we don't get. So the Medicare is the biggest one. And so I would just say on the plaintiff side, if you can help these guys on the Medicare thing, because that's the one that they're really just so concerned about.
Yeah. And usually on the best practice on the Medicare side for the plaintiffs is on intake, you open that up right away, whether there's one there or not. You get that authorization, you get that going, and you get your letter or your notice from them as quick as possible, because you don't want you to be waiting 90 days or 120 days for a Medicare letter that should have that's a $0 amount, right? That could have been gotten, in the first 2 weeks of you signing up to claim. So those are the things that that you can get out in front of that. So it makes it a lot smoother. So then if they say, hey, we need Medicare, oh, here's the Medicare letter. There's no lien, or it's X amount and we've agreed to take care of it, or write a separate check if you want, which I'm not a really big fan of, but whatever.
Because I know we got a few minutes here. We talked about, the statutory requirements on settlement demands. And this is the statute you mentioned earlier, Chris. This is 537058, passed back in 17. Just the language here in the insurance companies focus on the statute a lot. Also, a lot of coverage counsel that don't do Missouri when they're helicoptered in to handle difficult cases, they focus on this statute as well. And, it essentially says a time limited demand to settle any claim for personal injury, BI, or wrongful death shall be in writing, shall reference the section, sent certified mail, requested to the tortfeasor's insurer, and it has all these material terms that it has to have. The big one there I have in bold is that it has to be, you have to give them 90 days. The amount of payment requested has to be there. Missouri has clarified in one of the few cases talking about the statute, you actually have to put the dollar amount that you want or say policy limits, and policy limits means the limit listed on the deck page, right? And so you have to, you can't just say I want first aid and it's just some unknown number. You have to tell us the number. Some other details here, description of the injuries, the big one, the parties to be released, the description of the claims to be released, so on and so forth. You have to have, and I don't have it up here, but authorizations for employers and hospitals, and Chris described it as onerous. This was, I think, a response to the Johnson versus Allstate case, where there was a settlement demand and Allstate kept calling plaintiff's counsel and asking for, will you send me the medical? And plaintiff's counsel's like, yeah, no problem. I'll send it over. And then the time passes and now Allstate's in a situation. And so I think this was kind of a response to that. And it's kind of funny, Chris, because I think California after this passed their settlement demand statute, and a lot of it's a copy and paste from this. If you
But they got a lot better post-judgment interest and interest from when you don't accept the demand. In California, I see these guys get like 35% on top of their verdict.
Yeah. So they copied our. So I like to say California got three things from us: the Rams, Albert Pujols, and a version of the settlement demand statute. Okay. So, but like the big thing we've been, and again, if the demand doesn't work, then it's not supposed to be admissible in any lawsuit alleging EC damages, i.e. bad faith, against the tortfeasor's liability insurer. But the $64,000 question is, does this apply to all demands? Right?
Yeah.
Because you can see in the beginning, it says time limited demand. That's actually a defined term. And there it is. An offer to settle any claim for, these things, which by its terms must be accepted within a specified period of time. And there was actually an Eastern District case that I think it was Jameson versus Still, where the Eastern District, a panel of 3, issued a holding that said that this applies to all settlement demands, even those that don't have time deadlines on them. That case went to Supreme Court. Supreme Court issued a decision on different grounds, vacated the Eastern District's decision. So we don't have that case law anymore. But, for about 6 or 7 months, Chris, it was great, because we had, at least from my side, because we had that holding, and now we don't. And so now the big thing that we see in our cases is we get so many, or at least that come to me, are settlement demands without time deadlines. And the insurance company sometimes automatically assuming, well, if it doesn't do all this stuff, it doesn't count.
Yes, happens all the time. You get a call like that, like, oh, we didn't comply. Well, I don't know. I sent you something. There's no time deadline in it. Take all the time you need, I guess.
That's right. And so it has no time deadline on it. And so maybe by day 30, it gets pulled, and they're like, well, wait a second. We thought we had 90 days. Like, well, maybe you do, maybe you don't, And so I think this is one of the big potential traps out there for carriers is, these demands that don't have deadlines on them. And we've seen varieties of them. You maybe done some of these, Chris, where you don't put a time deadline on it, or they'll say, if this is not accepted in 30 days, we're going to file suit, right? It doesn't say the demand's pulled, but so is that a time limited demand? So in my practice, this is one of the key issues is we have demands that give us some information, not a ton. And what do they do with it? The other thing so where does this all end up? It ends up basically with this notion of bad faith, right? If we don't accept a demand on the carrier side and is that bad faith or not? And to me, this is still something in my mind that's still not settled either. What is bad faith in the state of Missouri? Because you have across the country, it's kind of like a continuum. There are some states like Connecticut where you have to basically be dishonest. New York, you have to like intentionally disregard your insured's interest. Arizona's kind of in the middle. Texas, with stowers is like a negligence standard. You go all the way to West Virginia, it's strict liability. What is Missouri? Well, here's Missouri, as far as I can tell. This is the Johnson versus Allstate case, right? And it actually does all kinds of different things. I have this language in here bolded. Good faith obligates the insurer to sacrifice its interest in favor of the insured. That sounds like West Virginia. That sounds like almost strict liability. Then it goes on and says the intentional disregard of the financial interest of the insured. That sounds like New York. Then it goes on to say the insurer must act honestly. Well, hell, that's Connecticut, right? And then like, what's our proof? These things: not fully investigating and evaluating, not recognizing the severity, not recognizing the probability, refusing to consider a settlement offer, not advising the insured, except for that third at the bottom, refusing. These all sound like negligence, right? That refusing to consider, that's more intentional. And so what are we? And so when I get these settlement demands and people are saying my clients are in bad faith, they quote Johnson versus Allstate. But what is our standard here? And it's clear if you have something that's on the screen, a judge is going to let that go to the jury. But it's really what kind of instructions are out there? Because there's no MAI on bad faith. We don't have a definition instruction on bad faith. And so in these cases, that's the fight, right? What is the judge going to let us submit, if anything? What do we get to say? And of course, the plaintiffs, Chris's of the world, want that bold. That's our definition instruction right there. And so that's the fight in these cases. And until Supreme Court or somebody clarifies this is as much a fight in the state as anything else. Chris, any comment on that? Disagreement?
I'm in agreement, and I like all the language in there. It gives me I like a buffet to choose from, Mike, rather than just a single serving.
Yeah. See, I kind of like this part down here where it talks about honestly. See, because it says, my argument is they said honest twice. That must mean that's the standard.
They weighted it that way, right?
They weighted it that way. Exactly. Yeah. So I think we're at 11 o'clock.
Yeah.
Fellas, fantastic. I want to point all of our attendees to your materials because I know this is a broad area. Take a look at a couple of these key cases. And like I mentioned before, it's shifting sands, and we're going to continue to see the evolution of this particular area. So Mike, Chris, thank you both giving us the plaintiff and defense perspectives on this area that will continue to evolve. We're going to take just 5 minutes, but just a couple of things I want to mention. First, I want to thank everybody for coming today. With your donations for this CLE, it allows us to provide various nonprofits for each of our seminars with funds for their nonprofits. And in this particular program, there are 5 in the local area. So it's Legal Services of Eastern Missouri, Land of Lincoln Legal Aid, Beyond Housing, St. Louis Survivors Legal Support, and the St. Louis Mediation Project. And all are outstanding local nonprofits, and they certainly can appreciate some of the donations that we make. In terms of housekeeping, those seeking the Missouri CLE certificate, in the portal, you can get a copy of that certificate. Those who are seeking Illinois CLE credit, you will receive that from Kelly Spiller of our office. And speaking of Kelly Spiller, she's the one that really puts this together, and we couldn't do it without her. And all of us owe her a debt of gratitude for all the fine work she has been doing, not just the last couple of years, but for the past 15 here at USA&M. The last thing I'll mention, in the portal, there is an evaluation form. And of course, we want to know how you think things went today. But the most important thing you can provide to us are new topics that are of interest to you and perhaps potential speakers on those topics. We have yet to craft the next program that'll be in the first quarter of 2025. And really, we would like to do that based on your comments. So you can go into the portal, the evaluation form is there. If there's any issues with that, you can certainly email Kelly or reach out to me. We'll take 5 minutes and then we'll get started with the next program. All right, folks, we are in the home stretch. Our last program, use of decision tree analysis and litigation, client communications, and mediation. Our presenter is Mark Walker. Mark is the newest member of the USA&M mediation panel. And Mark has a unique background, having come from practice in both Illinois and Texas. Mark is coming at this from more of a commercial business perspective, as opposed to a good part of what we do, what we've just heard about in terms of medical malpractice, personal injury kinds of claims, death claims. His experience as a general counsel of companies like CompUSA and other positions as chief legal officer really makes him a unique entity within our organization, because he has had focus on business, commercial litigation, complex commercial issues, employment, partnership, LLC cases, commercial leases, business competition, False Claims Act cases. And these kinds of decision trees, frankly, relate to all the kinds of disputes that we see. And Mark, we look forward to your talk. Thanks so much.
Rob, thank you. I hope that everybody can see me. If not, that's fine. And I hope that everybody can see the slides. I was telling Rob during the break that I'm about to take you from an in-depth evaluation or presentation regarding malpractice into a more general presentation regarding something that, as a former general counsel and as somebody who does a lot of corporate work, has always had a concern about, and that is how to best evaluate risk, whether it be litigation risk, settlement analysis, mediation opportunities, or client communications. It all involves risk. At the very outset of this presentation, I'd like to acknowledge that I have borrowed quite liberally from a text that is out there on this topic. And Rob, you may want to change the slides for me because it's not working on my end.
I tell you what I'd like you to do is stop sharing.
Okay.
And I will.
Let's see. I got it.
Just a second. Slideshow from the beginning. There you go. And just tell me when to advance the slide.
Okay. Let me see what I got here. Can you still see the slides? Because I do not see them.
Oh, yes, I do.
Okay. I just want to let you know that I borrowed quite liberally from a text that is out there today. It's called Risk and Rigor, a Lawyer's Guide for Decision Trees and Assessing Cases and Advising Clients, that was written by Marjorie Aaron. It's a spectacular text if you haven't used it before or seen it before. And after perusing lots of materials regarding decision trees, it became clear that this was going to be the basis for my presentation, because it does such a great job of walking people through it. One of the things that you'll note in the first slide is that decision trees have been around for a long time, and they've been used in the management world for a long time. It hasn't been until early 2000s, 2010s that decision trees started making their way into legal analysis. But as you get to understand how they're used and what they can be used for, more and more people should be using decision trees in their legal practice. And not so much for maybe trial prep, but certainly for educating their client, having conversations with their client, educating mediators and arbitrators. So what exactly are decision trees? They are within a world called decision analysis. Decision analysis is something that attorneys do every day. You're simply applying accepted logical and analytical methods to decision-making tasks that involve choice, uncertainty, prediction, and data. Decision trees are nothing more than a visual representation of the thought process, of the analytical process that a lawyer goes through. And the branches of the tree show the logical flow from a given decision and the consequences of that decision. One of the keys to a decision tree is at each point where there is a decision, you assign a value or probability to that particular decision point or node. And that probability then carries through to the end of the tree to come up with a value for the decision analysis. Do you have to use decision trees? Obviously not. They've been around a long time, and some lawyers use them constantly. Some mediators use them a lot, but it's a matter of choice. You can get the same results using a spreadsheet, a whiteboard, flip chart, whatever. But my experience has been that the visual representation of the tree is a really valuable tool in educating clients. Teaching even senior executives, CEOs, showing them what the case looks like. It illustrates the complexity of a lawsuit. And even if you don't do the math that typical decision analysis and decision trees call for, merely building the tree out and showing the client the complexity of the case, or in some cases, the simplicity of the case, can be really helpful in making sure that your client is informed, understands the litigation, and is in a position to make informed decisions when they're discussing settlement opportunities. They can be helpful in managing the risk analysis. Every attorney out there, every litigator out there is evaluating the risk of the litigation every day in every case. And using a decision tree can make that risk analysis clearer, more comprehensive, but even more important for the client, understandable. It answers questions like, or helps to answer questions like, what's next, or what happens if, and what's the game plan? What are we doing? Every attorney deals with tricky issues and complicated analysis every day. Questions like, should we file in state court or federal court? Is there an expert out there that will support our theory of the case? This is a particularly good one for me, having been in the corporate world. Will our arrogant CEO anger the jury? I mean, these are all questions that influence the way an attorney will think about a case and the probabilities that an attorney will assign to a particular decision or decision point within a case. Another one that is really important is thinking through, what if everything doesn't break our way? Very frequently attorneys get their clients' expectations raised by talking about how things are going to go or how they think things are going to go, but they really don't stop to think about what happens if it doesn't go our way? What are the outcomes? And knowing those questions, being able to ask those questions in a logical and straightforward way and discussing them with their client goes a long way toward avoiding misunderstandings with clients. You may have noticed already that I think the big purpose or big value is the visualization of a decision tree. Um, it helps everybody see what is important and how things link together. Other questions that attorneys face that a decision tree can help them evaluate are set forth on this slide. What are my client's rights and responsibilities? How do I best protect those rights and interests? What are the ultimate professional, financial, personal, and business implications of a decision during litigation? Those are all important considerations. And here's what typically happens, at least from my experience. Those kind of questions get asked, the simple what ifs or what's next questions. And the lawyer, outside counsel, or the general counsel will put together a 20-page memo or 20-minute presentation that covers everything, the substantive legal issues, the potential rulings, the critical evidence, damage theories, everything's in the memo or the presentation. But it's really hard for a client, especially an unsophisticated client, to understand sometimes what the lawyers are saying. If I go to Professor Aaron's text, this is an example of what happens typically. The lawyer will respond to the client's questions with something like what you see on the screen. The initial question is whether to file suit, and if so, where, what venue. We should defeat their statute of limitations defense, but there's case law out there that's concerning. If the other side can keep the evidence out, or potential upside on damages will be, and it goes on and on. And I've been the recipient of memos like that and presentations like that. And I got to tell you, even if I understand the presentation or the client understands the presentation, it's filled with a lot of legalese, and it's very likely that the next few questions from the client will be along the lines of, well, what do we do now? Should we try to settle? What's the case worth? What's the lowest we should offer? What are the chances of hitting a home run or the chances of running into a disaster? Even if you do great presentations with legal pros, those are the kind of questions that you leave your clients with. And this is where decision trees can help. They can help you make informed presentations, and help your client make informed litigation settlement decisions. There's no way that prose analysis can adequately accomplish the preparation and information needs of the client and penetrate the black box that the client will have with a lengthy memo or a presentation. There's no prose that a lawyer can use that'll be transparent as a numerical estimate of the value of a case. And frequently, when clients are asking the lawyer, what's the case worth? What should we do? The lawyer frequently pulls an answer out of thin air and either answers it poorly or avoids answering it all. So there's a huge disconnect that can be avoided if you use decision trees. Why is that? Why does that eliminate, or is a step toward eliminating that black box? Well, it's a visual display. And because it's visual, it helps the lawyer and the client understand the case. It helps to illustrate the complexity and nuances of each decision point along the way. And most importantly, if you do the math it's called for by a decision tree analysis, it helps quantify how those decisions impact the litigation. But even if you don't use the math, even without the application of probabilities, if you take the time and sit down and prepare even a rudimentary decision tree with your client, it really does help the client understand what the lawyer is doing and why. And too frequently, that's a big stumbling block in moving forward with a piece of litigation or settlement. The client simply didn't understand or doesn't understand. I mean, We hear this all the time in mediations. I hear it all the time in litigation discussions with outside counsel. Questions or comments like, if this case were tried 100 times, how would a jury rule on liability or punitive damages? What are our chances of summary judgment? What are our chances on a motion to dismiss? It's a very high level, very vague conversation, and it's really hard for the client to get into the same league with the attorney and understand what the thought process really is. Why is that? Well, because as lawyers, we're trained to do those types of analysis inside our head. We think and we evaluate subconsciously. We evaluate courses of action and decision making. We assign probabilities to outcomes, but it's all inside our heads, and it's truly a black box to the client. And that's makes it difficult for people to understand what is going on and why things are happening the way that they are. Decision trees help avoid that. Okay, here's the trick question. Did you know that your odds of winning the Mega Million tonight are 50-50? Yep, it's you either won it or you did not. It's a 50-50 proposition. And we all know that that's not right. But as I know, there are a few of you probably paused and might actually go out and buy a lottery ticket tonight. If you try to explain to somebody why that answer is wrong, why it's not 50-50, intuitively, it sounds very easy to do. But when you actually try to explain that, the math and the concepts are pretty complicated. And it's much easier to explain why that answer is wrong when you do it visually. It's the same with litigation analysis. It can be very complicated, very nuanced. And decision trees can help attorneys explain it in a way that's visually understandable to the client. It forces everybody to slow down, to think in smaller and simpler segments. It forces the lawyers to slow down and to consider all of their instincts and hunches and estimates and conclusions. And when those are mapped out in the form of a decision tree, the black box nature of your thought process disappears. Decision trees, I believe, are a better way to communicate with clients. It has a great ability to lower anxiety and stress. Most importantly, I think, is that it relies on analysis and it takes emotions out of the equation. And it provides a visual representation. You guys may have picked up that the visual part of this is probably one of the most important things in my mind. So if you use a decision tree, whether you use the math and the probabilities that is typically called for, you don't have to do that to have the impact of a decision tree. You don't have to fear the math. And a lot of people look at a decision tree and they're like, I just don't understand it. How does it work? And it gets confusing perhaps when the tree is complicated or when you have to do the probability math that's involved there. But you don't have to do that. Merely presenting the case in a visual format helps. The other thing that's important to understand, as a lot of people object to, is that they think that decision tree analysis gives a settlement value to the case. It's not what it's doing. It's not presenting a value that the case should or must be settled for. It's simply giving an estimated monetary value of the case based on the various decisions that need to be made and the probabilities that are assigned to those decisions. It's a data point. Something that everybody needs to remember if you're using decision trees is that it's up to the client to treat the analysis as a settlement value, that's something they should try to settle for, or to just see it as a data point. And it's up to the client to make that choice, but it does provide information to the client. And at the end of the day, if the client disagrees with the analysis or the estimated monetary value, the client's free to say, I'm just not going to settle It just doesn't feel right, regardless of the value. So I'm hoping at this point, just based on the high level, here's the value of decision tree analysis, you're all thinking this might be something you might want to do. But before you jump in, you need to know that there's some things you need to learn to do. Obviously, you need to identify the issues. You need to be in a position to analyze the options. You have to be able at each of those options to assign a value, define the odds. What are the chances of that option occurring or not? You need to be able to recognize what the net gains and costs of the litigation are. And that means, as you'll see later, that you can't ignore attorney's fees, intangible costs, non-monetary things. You have to deal with the net outcomes of the case, not the gross outcomes, not the jury award, but all of the costs that led you up to that point. And then at some point, you need to be able to multiply the probabilities along each branch of the tree to find the cumulative probability of each possible outcome. That's the estimated monetary value. And that's the part where most people say, basically, do what? Here's the basic analysis. Decision tree analysis follows the basic rule. It's a probability theory. Whenever you have to take one or more action or make one or more choice to reach a given goal, and the outcome of that particular action or choice is not 100% certain, then the probabilities of each choice or action encountered on the way to that desired outcome must be multiplied. On this next slide, here's the basic way probability theory works. And a lot of people struggle sometimes with the coin toss probability analysis here. And if you struggle with it, think of, rather than a coin toss, an obstacle course where you have three things. In this case, we have three flips of a coin. But if you think of this in terms of an obstacle course where you have three things you must accomplish to go ring the bell at the end, then you assign a probability to each of those three things you must accomplish. Multiply those probabilities together, and that cumulative probability is the likelihood of you accomplishing the mission and ringing the bell or not. So if you look at this coin toss, if I want to know what's the likelihood of me flipping a coin three times and it lands on heads. It's not a weighted coin. It's not a trick coin. It's a regular quarter from my pocket. Well, you can see that if I want to land three times on heads, there's only one path it can take. And along that path, each time I flip the coin, it's a 50-50 chance. And when I multiply that 0.5 probability for each flip that it will land on heads, I have a 1/8 probability that I can do that three times in a row. That's the basis of probability theory that decision trees are built on. And you have to really kind of get comfortable with that before decision trees make sense. So these slides are not in the presentation that, these next 4 slides are not in the presentation that got sent out, but I recognized I need to add them. This is a basic decision tree, very fundamental. It's dealing with a contract case. I made it up. It's just to show you the elements of a tree. And to the left, you'll see the red box, which is called a decision node. The yellow circles are called chance nodes. The green triangle at the end is a terminal node. So every time you have a decision, you'll encounter a red box. And from that red box, you'll have decisions to make or opportunities to be confronted with. Those are the chance nodes. Chance nodes can be broken down into any number of things. In this case, we're dealing with a contract case where the first issue will be summary judgment. The second issue will be if summary judgment is denied, then there are 3 potential outcomes. I can win all the claims, and there are fraud and contract claims. I can win the contract claims only, or I can lose all claims. And the terminal node there in green indicates that if I lose all claims, there's really not any other opportunities or chance nodes or any other things to happen. The case is over, the tree is done at that point. You'll see that there are places on the tree, the blue numbers to the far right are where I will be putting in the probabilities. The dollar placeholders, where it's $0, are where I will fill in the payoffs as we go along. So this tree demonstrates the insertion of the probabilities. Here I believe there's a 25% chance that summary judgment will be granted, a 75% chance that summary judgment will be denied. If summary judgment is denied, we head to trial, where I believe I have a 35% chance of winning all claims, 25% chance of winning only the contract claims, and a 40% chance that I won't do a very good job and I'll lose all the claims. The next iteration is I want to be able to quantify, what the outcomes are at each branch. What's the payoff? Well, if summary judgment is granted, and you'll see, I think there's a 25% chance that will happen, then I'll have no recovery, but I will have incurred $5,000 in fees and costs through summary judgment. So my impact here is a minus $5,000. If summary judgment is denied and I win all claims, of which I think there's a 35% chance I will do that, then I've made up this result. It's a $300,000 jury verdict, but I will have spent $30,000 in fees and costs through summary judgment and trial. And that $30,000 includes the $5,000 I spent to have summary judgment not granted or denied. So my net recovery, if I win all the claims, would be $270,000. Same kind of analysis for if I win the contract claims only in the next line down. It would be a $100,000 award, but I'm still going to spend the same $30,000 to get there. And then if I lose all claims, I'm going to spend that $30,000 with zero recovery, and that's reflected in the one with the terminal node at the bottom. So now what happens when I load those outcomes into the decision tree? You'll see that the dollar amounts have been fed into the decision tree under each branch, the minus 5,000, the 270, the 70, and the minus 30. And you might be scratching your head saying, well, what's the $100,000 next to the yellow circle? Well, all of these results now are final results. They're the outcomes. So they've all ended in terminal nodes. And as you walk through the tree, you'll see that the probability of the outcome for summary judgment granted is 25% if I go down that branch. As I go down the branch for summary judgment denied, what is the probability that I will win all claims and recover my $270,000? To the far right, you'll see that the probability of that occurring is only 26%, a little more than 26%. The probability of recovering the $70,000 is a little more than 19 or 18%. And the probability of losing all claims and spending $30,000 for a bad trial is 30%. Those probabilities are the cumulative probabilities of each of those branches. To get the 26% probability at the top there, you multiply the 0.75 by the 0.35, and that gives you your 26%. So what's that $100,000 back by that yellow circle? That represents the total estimated monetary value of the case at that particular point in time. Summary judgment was denied. We went to trial. These are the three potential outcomes from going to trial. And when I take each of those payoffs at the end and multiply them by their probabilities and add them together, I'll have $100,000. That's how the estimated value of the case is before trial, after summary judgment is denied. You see to the far left, there's a $73,000, $750 number. That's nothing more than the total estimated value of the case before summary judgment occurs. So I wanted to walk you through a basic tree like this, just to give you a view of how they come together.
And Mark, just so you know, the PowerPoint that I have did not have your updated last couple of slides. So the general tree is there with some of that analysis, and then we will email those updated slides to everyone so they have them.
Okay, did you not see them as I was presenting them?
No, because I have
Okay.
my screen that I'm sharing.
Okay. All right. All right. So on the next slide, here's an example from Marjorie Aaron's case, or her text. This goes back to how do lawyers talk to their clients, and how exactly, what does the client hear, and how do you deal with that in a decision tree format? And Rob, this is a slide that has "that's great, but" at the top.
Yep.
Okay. So you explain the case to the client, you did a great job, and here's what the client tells you or repeats to you. If I understand what you told me, if summary judgment goes my way, I will get $500,000, but pay $30,000 in attorney's fees between now and then. If I lose on summary judgment, I can still win on liability, and I'll pay an additional $40,000 in attorney's fees through trial, but we'll collect $500,000 in damages. If I am found to be partially negligent, say 20%, I will only receive $400,000, but I'll still pay $40,000 in fees. But the defendant's bankrupt, and it may be a long time before I see a dime. How does that look? How does that prose look in a decision tree? That's the next slide, Rob. Well, it looks just like the decision tree here. You have two paths to go from the chance node. Win summary judgment, lose summary judgment, go to trial. If you win summary judgment, your recovery is going to be $500,000, but you'll spend $30,000 in attorney's fees and costs, so your net recovery will be $470,000. If you lose summary judgment and go to trial, you see the analysis there. I think it's pretty obvious and self-explanatory. But you'll notice in this slide, there's no probabilities. It's just, here's what the client thought they heard. But being a typical client, they heard that, and you show them that raw, basic decision tree, and they say, what does all this mean? What are the chances of this happening? And the next thing you'll probably say is something like, well, it's hard to say. Typically it's difficult for plaintiffs to get a win on summary judgment, but I think we have a pretty good chance, and on and on. The pros from that would look something like the next slide in a decision tree format. Again, no probabilities, no real numbers. It's just the pros of the lawyer put into the form of a decision tree. Win the case on summary judgment, it's kind of hard, but maybe. I think you can all get the drift of this slide simply by looking at it. All right, so is that decision tree good or bad? Was it helpful? I mean, if you go back to that slide again and look at it, is it helpful to present a slide like that to your client, or a decision tree like that? And my unambiguous answer is absolutely. I would have no problem absorbing that as a client or presenting that to a client, because it really helps show the path that the case can take. And if that's all you do, I believe it's extremely valuable, but there's a lot more that decision trees can do. And so, Rob, we should be on page 29. Before I go through what decision trees can do that's more, here's another example of why they can be important and how they can help clarify the communications between a client and the attorney. We frequently use that the outcomes are highly likely or quite possible, or this outcome is a slam dunk or just about a slam dunk. There's a pretty good chance that we'll see this. And as a general counsel, I was left with, okay, what does that mean? Are those comments clear? Are they clear to you? And here's the one that's most important. What does your client think they mean? When you say it's highly likely or just about a slam dunk, I mean, I, as an attorney, might hear you say one thing. My CEO may hear something entirely different. Highly likely to a CEO is very likely to be, we're going to win. Well, Professor Aaron did some studies with her class, and this is the slide on page 30. She presented a number of different descriptors to her class and asked them to assign probabilities to them. What does it mean? How do you translate that into a probability? And this is, I thought, perhaps one of the more important pages or slides in her text. Something, when you say it is very likely that X will win this lawsuit, the class participants rated that statement to be a 90% chance to a 50% chance that they'll win. If you go down, there's a more dramatic one. X should win this lawsuit, an 83% chance to 35% chance. Go to the bottom. Your case is shaky on liability. The class saw that as being anywhere from a 55% chance of winning or a 20% chance of winning. And this slide is really important, and it's important in the context of decision trees, and it's important in the context of mediations or arbitrations, because the client's expectations are frequently out of line with the realities of the case, and with what the mediator or the arbitrator may think the case is worth, or what your opponent may think the case is worth. And a lot of times, it's my belief that expectation is misset because phrases have been used like this: you should win this lawsuit, or it's extremely likely that you will win. And the client hears something different than what the attorney intended to convey. So if you go to the next slide, you're all probably wondering, how does this relate to the real world? Again, in Professor Aaron's text, she has a couple of what she calls real imaginary cases. Here's one. I'll give you it from, here's the basic fact pattern. If no settlement is reached, defense will move for summary judgment. Plaintiff has an 80% chance of defeating the summary judgment motion. Plaintiff has a 60% chance of winning at trial. If the plaintiff wins at trial, the damages award will clearly be $150,000. The plaintiff has a 1/3 contingency fee agreement. Expert fees are deducted after deduction of attorney's fees. Expert fees of $10,000 will be incurred after summary judgment motions through trial. And if there's no recovery, the plaintiff attorney knows he will not be charging the plaintiff for the expert fee reimbursement. So it's not an atypical fact pattern. It's not something that is unusual. But what would the plaintiff's decision tree look like? And here it is. This is a completed tree. It shows that if summary judgment is granted, the plaintiff gets 0. There's a 20% probability that that outcome will occur. If summary judgment is denied, there's an 80% chance that that would be the outcome. There's 2 possibilities after summary judgment is denied. Either win at trial or lose at trial. If you win at trial, your net recovery is $90,000, which is $150,000 minus the $50,000 in K, or $50K in fees, and $10,000 expert fees. If you lose a trial, well, there's no recovery. You roll this back, and when I say roll it back, you apply the probabilities to the payoffs or outcomes, and you'll see that after summary judgment is denied, the estimated monetary value of the case would be $54,000. Again, that's not a settlement value. That's just what somebody might be willing to pay you for that case. The total before summary judgment proceedings, the total estimated monetary value of this case from the plaintiff's perspective would be around $43,200. Next slide. You can ignore that. What does it mean? I just walked you through that. But let's go look at this from the defendant's perspective. Again, it's a different perspective, and you end up with a very different tree, very different analysis. You can read with me, in the absence of a settlement, defense will move for summary judgment. I estimate there's an 80% chance of plaintiff defeating the summary judgment. I estimate that the plaintiff has a 60% chance of winning at trial, which means your client would have a 40% chance of no liability. If the plaintiff wins at trial, the damage award would be $150,000 and on through the end of this fact pattern. Okay. So if you go to the decision tree, how it would look for the defendant in this case, it's a very different decision tree. In this particular one, I've not put in the payoffs yet. I've put in the probabilities. And then on the next slide, let's see what we can learn by adding the probabilities and completing the tree from both sides of that hypothetical. Okay. From the plaintiff side, we've already seen the tree. It shows that after summary judgment, there's an expected monetary value of $54,000. Before summary judgment, given the probabilities involved, the expected monetary value would be about $43,200. Here's what it looks like from the defense side. You'll see that we're incurring costs at each of the terminal nodes. And as we load those costs and exposures into the tree, before summary judgment, the far left, the expected monetary value of the case would be around $101,000. And after summary judgment is denied, the expected monetary value of the case would be about $125,000. That's what I would expect my exposure to look like given the probabilities that are involved. And at this stage, I don't know whether I'm going to win a trial or lose a trial. So those probabilities get calculated. They get multiplied by the outcomes at the end to the right of the decision nodes, and they get added together to come up with that $125,000. What does your client do with this? Well, the client looks at that and they may say that, you know, they will never settle for $125,000, or they may see that as something that's a good value to consider. Plaintiff may just reject that out of hand. But what it's doing is it's giving you an idea of what the case looks like, what the exposures are, and it puts a dollar figure on those exposures that should be able to help you discuss settlement with your client and help discuss settlement with the mediator or the arbitrator. One of the things that you always have to keep in mind when you're building a tree is you have to do net outcomes. That's the, if I go back to the prior slide, you'll see that on every decision, or actually every terminal node, it's not just the recovery or the exposure, it's the fees and expert costs. If you don't include those, you're really not dealing with reality. You have to include those because those are hard costs. And don't forget, and I'll talk about this in a second, to discuss intangible costs with your client, especially if your client is a business client. Those intangible costs are hard costs. They can be monetized. You can add them into the costs of the tree to have the expected monetary value be much more realistic than if they are ignored. The other thing you don't do, and a lot of clients object to this, is that you never include sunk costs in the tree analysis. Once the money has been spent, if you're building a tree after funds have been spent or costs have been incurred, you only use the costs and expenses to be incurred going forward. If you include the sunk costs, witnesses that you've already deposed or deposition costs you've already incurred, you're not going to get those back in the course of the litigation. It's unlikely that you will. And including the sunk costs skews the outcome, the expected monetary value of the tree in a way that renders the tree less meaningful to the client and to the analysis. So let's talk about intangible costs for a minute. For a business, the CEOs, the CFOs, they only want to look at the dollar costs of litigation, and it's up to the counsel, the outside counsel, the attorneys to educate the client on what their intangible costs might be. And having been through litigation as an in-house counsel, I can tell you that these costs are substantial, and they are frequently ignored by the business people. The distraction of the organization, the time spent on unprofitable work. This is a huge one. Electronic discovery, time and expense. It's an enormous expense in litigation. The damage to business reputation and relationships, that's a little bit harder to monetize, but it's still a cost. And you may actually find the client misses business opportunities. Either clients don't come to them or business doesn't come to them by the sheer existence of the litigation or the conflict. And you can put monetary value on those too. For an individual that's involved in litigation, the intangible costs are just as serious. They're a little harder to put monetary values on, but they include time, and that's the biggest, the time away from your work and your family, the uncertainty of the litigation, the impact on family and relationships, lack of control of the outcome, the aggravation, the risk, the stress. And it's the stress that creates the impact on the family. It's the lack of control that creates the stress. The intangibles are large in personal litigation, and mediators and arbitrators and counsel will do everybody a huge favor in reminding individuals of these intangible costs and impacts of litigation. One decision or one issue of decision tree analysis is how big should it be? How far should you make it? And I'm not going to go through all of the information on this slide. I think I've summarized it well in the title. Should it be a sapling or a sequoia? And I got to tell you, decision trees can become sequoias. They can be huge and very complicated. And if early on in the process, I get a sense that it's going to be a very big or complicated tree, I typically discourage the use of them because a decision tree that's too huge and too complicated becomes counterproductive. It becomes an obstacle in itself. So the objective is to keep the tree as simple as you can, to make sure that you include the key points, the key decision nodes and chance nodes that you need, and not to overthink it, because the more you overthink the tree and the more nodes you add, the bigger the impact of the probabilities are. Remember, they are cumulative probabilities. And for every branch that you add, every node that you add, you're adding a probability that impacts the estimated monetary value. So the more complicated the tree, the less valuable the actual math becomes. Rob, I don't think I have much time left. I've included an appendix here, which is another example from Professor Aaron's text. It's an extremely good one. It's based on an actual case. It's not a make-believe case. And it's an extremely valuable fact pattern that includes the decision tree filled out to the end. And you can see just from this decision tree at the last page of the presentation, how complicated they can start to get. And this is not as complicated as I've seen them. But I guess if anybody has any questions, I'll entertain some questions now. And I'll open it up for that.
Mark, you touched on one just a minute or two ago, and that is the intangible cost. And especially for the business client who is a novice to litigation, who hasn't gone through it, who doesn't understand the timeline and the costs involved, right? How do you quantify that for with a client as you're filling out this decision tree?
So that's a great question. If you go back to the slide on page 39, Rob, the easiest one to quantify is time spent on unprofitable work. I will sit with the litigators, I will sit with the management team, and you can build a pretty good estimate of who is going to be deposed, who's going to be involved in the litigation, what their efforts are going to involve in terms of depositions or document production, interviews with outside counsel. And you can use that big picture analysis and use their salaries or their hourly rates or wages to build out an estimate of what the time spent on the litigation will cost the organization in terms of man-hour or billable hours. For organizational distraction, it's a little harder, but you can still do the same thing by looking at, again, who's going to be involved and how much of their time is going to be spent, and again, apply an hourly or salary-based rate to it. Electronic discovery, you sit with the IT people and you say, here's what we got, here's what we need, here's the parties involved, here's what the attorneys have told me they're going to need, all of their emails, all of their timesheets, all of their texts using company information or company devices. And that's one that is really a big ticket item for any corporate entity. It becomes a big ticket item. And again, when you sit with the IT people and start mapping out what the litigators will need, where are the databases, how big is the information, the IT people are pretty good at coming up with an estimate of what it will cost to produce those documents in that discovery. Lost business opportunities. It's not just lost business, it's lost potential advertising, it's distractions of the marketing and promotional people, of the advertising people. It's the PR folks perhaps having to distract themselves with how to respond to inquiries regarding this. It's preparation of public filings, if it's a publicly traded company, notification. I mean, again, you're looking at who's involved, what they'll be involved in, and trying to find a way to monetize that activity using salaries or base rates.
Very helpful. And you touched earlier on one thing I think that often gets overlooked, and that is the collectability of the defendant from the plaintiff's perspective, to factor that into their analysis, especially early on.
Yeah, it's, again, Rob, you've seen it, I've seen it in mediations where at some point you have to believe what the defendant is telling you. And if the defendant says, golly, I recognize their demand, I see what they're asking for, I understand that risk, I understand that if I go to trial, that's a potential outcome. But if that outcome occurs, I'm out of business. I'm going to be bankrupt. I'm going to be filing for bankruptcy. And, they can congratulate themselves on a Pyrrhic victory because it'll be uncollectible. That's something that a decision tree can really help with, because you get to the end you see what that is, you see what the possible outcomes are. And if one of those are the client is, or the defendant is bankrupt and everything that came before this was, well thought through, but you're not going to collect a penny, that's really important for the client to hear that before they charge down the litigation path than after that. I was involved in more than my share of litigation as general counsel for CompUSA. And we had a couple of cases where I had to look at the business people involved and say, look, yeah, we got a great claim. We can chase that. We can win that claim. But I can tell you from my experience with that particular vendor, their financial circumstances are not really good. And we can go chase them. The only thing that will happen is it will put them out of business. And I will have spent a large portion of my litigation budget chasing a Pyrrhic victory. It won't amount to much.
Very important information. Mark, thank you so much. I want to encourage everyone to take a look at these materials, and we will have a complete set of the updated slides forwarded to everyone, probably just the beginning of next week. Please remember to fill out your evaluations on the portal. I want to thank all of you for spending a rainy Friday morning with us. 3 great programs, thanking all of our speakers, moderators, and again, thanking all of you for joining us. Be on the lookout. First quarter of 2025, we'll have what will be our 90th Best Practice CLE. Have a great afternoon and a great weekend. Thank you all.
Thank you, everybody.